Okay. Good morning. This is a convening of the Massachusetts Gaming Commission. We're holding this meeting virtually, so we'll do a roll call. Good morning, Commissioner O'Brien.
Good morning. I'm here.
Good morning, Commissioner Hill.
Good morning. I'm here.
And good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Maynard.
Good morning, Madam Chair.
Okay, we're going to get started. Much of the meeting is a bit of a continuation from our last meeting on Thursday, March 23rd. But this is, we do have one item. This is public meeting number 445. And of course, today is March 27th, a Monday morning. I will start with our single item other than the regulations. Good morning, Director Lilios.
Good morning, Chair and Commissioners, and I am going to turn this right over to Chief Enforcement Counsel Heather Hall, who can brief you on this matter.
Thanks, Loretta. Good morning, Chair and Commissioners. As you are aware, the IEB has assessed an administrative penalty in the agreed upon amount of $20,000 upon Memoir, which is a nightclub that operates in the Encore Boston Harbor Casino. The assessment stems from two incidents of alcohol over service, one that occurred last August and one that occurred last September. Since that time, the IEB has been in regular communication with Memoir and the Chief of the Alcoholic Beverage Control Commission, which has been maintaining a presence in Memoir and in communicating with the Memoir staff. Memoir has been working to comply with the required corrective actions that stemmed from earlier incidents of noncompliance, and the IEB has seen improvements in Memoir's approach to alcohol service over the last several months. And I also note that Encore Boston Harbor is also aware of these matters. The IEB will continue to monitor and will continue to keep the lines of communication open with the ABCC, Memoir, and EBH with the goal of keeping compliance and public safety in mind. In closing, I just want to thank Senior Enforcement Counsel Kathleen Kramer, who was unable to be here today, for all of her work on these matters, as well as Attorney Zach Mercer and Brittany Costello. The IEB also appreciates the ongoing communications with the ABCC and Memoir's cooperation in the matter. Happy to take any question if anybody has any.
Questions for Heather? Commissioners? Commissioner Hill, I'm just going to ask if you're all set. As you get your video back on.
I am on.
There you are. There you are. Oh, were you able to hear Heather's presentation? Great.
I was. Yep.
Do you have any questions?
I have no questions.
Okay. Other commissioners, now that he's back. All right. Just a measure of the excellent report. Thank you, Heather.
Thank you, Chair.
Okay, then we're going to turn right to item number 3 on the agenda. There are a number of regulations that are cited, but we resolved them at our last meeting. This agenda had been posted appropriately before our Thursday meeting, so in order to make the 48-hour posting requirement. So as I understand, Caitlin, we're all set except for item D and J. The others we voted on and they move forward.
Yes, 205 CMR 202, authority and definitions, and 205 CMR 256, sports wagering advertising, are the two regulations that we'll be discussing today.
Okay. So should we turn to, who should we turn to next, Caitlin?
I would hand it right over to Mina.
Good morning, Mina.
Good morning, Madam Chair, and good morning, Commissioners. So we're going to go back to 256 this morning, and once we have resolved that, we'll do the final vote on 202. So far, we're not anticipating any changes to 202, but we'll see. So just to recap where we were on 256 when we last spoke on Thursday, we had talked through the entire packet of changes, we got some of your feedback on the changes we had suggested up to that point. We had also previewed the Attorney General's written comments and line edits, which we had received on Wednesday, the day before that, and had promised to take a closer look at those and provide additional recommendations on the AG's language. There were also a handful of questions that came up from that call that at the direction of the commission, we did reach out to the Attorney General's office and some of the folks at on First Assistant AG Moore's team to talk through, sort of make sure we understood their comments correctly. And so we have that feedback in mind. The commission has in its packet, starting on page 10, a revised draft of 205 CMR 256. To that packet, that draft has a number of items highlighted in yellow, which are the items that have changed in some way from our conversation on Thursday. The other red lines and track changes in that document are ones that we had discussed on Thursday, but I think we're all set with, so I won't recap those. So I'll be focusing on the highlighted changes this time around, if that works for everybody. Okay. So without further ado, I think we're starting off with substance right away. 256.01 1. This is an addition requested. Actually, we're not. This is a smaller addition requested by the Attorney General's office to make clear that the responsibility for the actions of affiliates or vendors extends not to just a contract, but any other agreement. This avoids someone calling it something other than a contract. So that is a fairly small change and made sense. So we added it here to avoid any doubt. Assuming no questions on 01, I'll go right to 03, which I think we do want to get the commission's feedback on the final language. If you recall, on Thursday, we had noted that the Attorney General's office had, in their prior March 7th comments and their verbal comments to the commission, advocated for keeping the original version of 256.01.3, which appears on page 10 in the struck out text. That's a second version of that. We discussed how you had since that time, or right around that time, I don't remember the exact chronology, had gone through the roundtables on this issue, had received input from the marketing affiliates and their counsel, the sports broadcasters group, as well as the operators on this issue, and then further, and obviously the further input from the Attorney General. We did speak with the Attorney General's office just to confirm that they had also had some of that background and understood the distinctions between the different models that exist for affiliate marketing, and understood that the commission has a policy decision to make. And so their preference is, as they stated on March 7th, to restore the language in full, but obviously it is the commission's call ultimately to try to balance all of the information you received. To that end, one of the suggestions I mentioned, and I think we previewed on Thursday, was language that tracks in large part the changes you made to 205 CMR 234 regarding vendors and vendor licensees and registrants, that attempts to, that would not be an outright prohibition on all of agreements where there is with a third party where the consideration is tied, or the compensation is tied to the volume of patrons or wagers placed, but some form of that. I'm going to, for the purposes of today's discussion, resist sort of splicing this too broadly into revenue sharing and CPA, because I think there are subcategories within it that may not necessarily be helpful, may have been helpful when you were reviewing the language for 234 and for the purposes of figuring out who gets vendor licensing versus registration. It sort of follows a New Jersey framework that I know we've all talked about a lot. Rather, I think what's important here is to keep in mind what this particular provision does. And that is as drafted, and there are portions of this that could be tweaked as discussed the other day. As drafted, this would prohibit an operator from entering into an agreement with a third party to conduct all of the realm of advertising, marketing, et cetera, in exchange for a percentage of net sports wagering revenue. That language, and I think Commissioner O'Brien, you asked why net, that comes from the licensing scheme, use the same language, and also New Jersey uses the same language. That's sort of the focus on it. Earned from users that the third party directs or causes, the causes to be directed was added just to make clear that it's just in case there's sort of a step in between, but it's clear that it goes that way. There are gradations of this. Right now, this would only prohibit this is both broader than what it could be and narrower. It's broader than prohibiting just users that actually place a wager on an operator's platform. The language could be tweaked to only prohibit that. It's narrower than, I think, one of the suggestions that we discussed on Thursday, where it would be simply an exchange for a percentage of net sports wagering revenue, period, in which case it wouldn't matter whether or not the revenue share was tied to the number of patrons that are directed by a particular affiliate. In other words, a operator could have a deal where if they make X revenue in a year, all of their third-party marketing affiliates get X percentage, regardless of who actually drove traffic to the site. So that would be prohibited if you take out the words starting, earned from users, et cetera. So there's sort of three different gradations that you could think about. This one is a sort of middle one. I will say one of the things that we did want to clarify with the Attorney General's office is the rationale that they had provided in their letter was the ability of a concern about third-party marketing affiliates acting as both drivers of customers and patrons to an operator, but also holding themselves out in other contexts as experts or tip givers to patrons who might place wagers. That is at the core of their concern here, is a sort of ability to benefit from that behavior. That is addressed in part by this prohibition. We also are, as we get later into the reg, we are suggesting some tweaks on the language regarding the provision of advice to patrons by an operator or a vendor, including a marketing affiliate. So that's I believe where we are on the lay of the land for this one, and I'll open it up, Madam Chair, to discussion.
Okay, commissioners, questions for Nina on this? Who wants to go first? Commissioner O'Brien.
Oh, sure. So, Mina, I'm just trying to gauge where this compromise language lands. So AG prefers to have the CPA and rev share bar retained in its entirety. Is that their ideal position?
Correct.
Okay. And then this comes from almost the hypothetical of, well, assuming you can't get that, then what do you suggest? Is that where revised 3 comes from?
Correct, Commissioner O'Brien, although I'm certainly not trying to forecast one way or another, but listening to the feedback the other day, we want to start with the language. I think I promised that we'd start with essentially the language that I had shared before or had on Thursday, excuse me. And so that's what this is, with the small addition of causes to be directed as just a slight gloss on it.
Okay. And then I have a broader question in terms of Commissioner Maynard had brought up a couple times Connecticut moving away from our initial language. Has anyone gotten any further information? I tried to look that up, and what I saw was legislation pending in Connecticut considering banning promos altogether in terms of advertising. Is there any information on if Connecticut is in fact doing it, and if so, why?
That's not something I am aware of, but that's not to say that it's not happening. I don't know if others on the call can weigh in.
Commissioner O'Brien, if you don't mind, I actually received a call from the Department of Consumer Protection in Connecticut on Friday, and they said that was actually not the case, that they were not, that would be a reg change, and that has not been in their pipeline just yet.
Okay, I actually reached out to them Friday. I didn't hear back. That was consistent with what I was seeing, but I just wanted to confirm. Okay, thank you.
Madam Chair.
Yes, Commissioner Hill.
So you know how I am, Madam Chair. I like it cut and dry, black and white. Mina, you and I had talked last week, and I just want to know, with the language that you proposed, we're allowing third parties, no revenue sharing for the most part, but CPA. Is that what this language does?
Correct. And the only reason I'm hesitating with those categories at all, Commissioner Hill,
I understand.
but to be fair, yes, it is. You would be allowing, CPA would certainly be allowed if it's in the sense that if any clicks on the site, that's completely fine. This particular language, however, would cover the form of CPA that, if you call it that, and I think that if you look at the New Jersey sort of framework, they do kind of split it into both revenue sharing and CPA on this. CPA in the form of percentage revenue based on a user signing up, that would be prohibited here as well. So the fact that they signed up, even if they don't place a wager, there's some percentage that goes that way. Revenue.
Understood. So Madam Chair, just a thought, for the last couple of weeks, if not few weeks, this is what we've been talking about. And I think this was the consensus that the commission actually came up with, is that we would allow the third parties. We were apprehensive about revenue sharing, but we seem to be okay with the CPA. So if this is what that does, then I feel very comfortable moving forward with the language that has been put forth by our legal counsel today. Short, sweet, to the point.
Yeah, I appreciate that, Commissioner Hill, because it was my question too. Mina, I think there's just a bit more nuance in that the current state of our reg does allow for rev sharing with a heightened licensure process, but not the reg, through our directive that suspended this license through a April 14th. So I would agree with you almost entirely. That was our position, Commissioner Hill. So I guess for me, the part of the rev share that you're carving out, or the part of the CPA that's carving out, I'd like to understand that better, because I don't know how the industry will feel about that.
And Madam Chair, I should just be maybe a little bit clearer than I was in response to Commissioner Hill. So the language is a percentage of net sports wagering revenue. So I may have I said this a little too broadly a moment ago. If someone does not, in theory, put any money into their account, they open an account and then say, you know what, I don't want to do this. It's not whatever percentage the operator has agreed to pay the third, whatever amount the operator has agreed to pay the third-party marketing affiliate for that activity, it would not be prohibited, because it's not coming as a percentage of net sports wagering revenue. It's the overall revenue that's generated from that user. So they would really have to place money into the account. And so in a sense, it is just on the wagers. Does that make sense?
Nina, is it very specific to percentages? Or does it also include, a flat fee amount? Let's say $50 is paid to the third party when a patron uploads funds into their account. Would that be permitted under this language?
That would be permitted. What's prohibited is exchange for a percentage of net sports wagering revenue. So it's a contingency fee arrangement of sorts.
Okay.
Can I ask a clarifying question? When our roundtable convened, and I did review the roundtable discussion again over the weekend, they said 90%, you all remember this, and more. Even I think some said 100% of their arrangements are CPA. And then rev share was distinguished, and they didn't slice it in maybe the way that we are here. Is this going to affect the industry? Or is what you're saying the rev share, because I need to understand it, like Commissioner Hill, black and white, is that part of what was considered rev share from the perspective of our roundtable discussion? Mina. Like in other words, is 10% of their CPA or 50% of their CPA include what you're prohibiting now? Or is it part of rev share in their minds? We know.
So the way I understood the marketing affiliate industry to be describing the distinction between CPA and revenue share in part had to do with the timing of when they're paid. I guess, Madam Chair, the reason I'm just pausing is I want to make sure my recollection of how they might think about it. I don't want to speak for the industry itself, obviously, but the only thing this would prohibit, I guess, just to go back to that, would be if they are earning a percentage from the bets actually placed. And
that would seem to be revenue sharing. That would
it is, yes. No, it is sharing of revenue, yes.
So I would assume it's in that,
right.
that slice. And then of course, what worries me is, Commissioner Skinner, your audio's off, right ahead.
Oh, I just hadn't turned it off again, Madam Chair. I was just waiting. I'm listening before I respond. I just want to make sure, like you and the other commissioners, that I understand exactly what this language is proposing to do. If I'm correct, just based on my review of all of the material we've received thus far, I think that this would allow revenue sharing agreements to continue. Again, as long as the compensation model isn't based on a percentage of net sports wagering revenue, but instead on something like the frequency of visits to a platform over time. And that's just as one example. And that's the way I understand the compensation models to work. I think there was some confusion, and then it resulted in my own confusion from Thursday's discussion that, whether the third-party affiliates are receiving compensation based on the amount wagered. So when a patron, or the higher a patron wagers, the more compensation the affiliate receives. And I don't think that that's the way it works. Like Mina, I'm not speaking on behalf of the industry. I'm just reciting, I'm just relaying my interpretation of all of the material and just discussions that I've had recently with a number of folks. So I think I'm okay with this language. I have to continue to digest it a little bit during the course of this meeting, but I think I'm okay with this language just based on my understanding. This would allow, the smaller third-party affiliates like Gaming Society that we heard from in our roundtable to continue to have a chance in the market, to continue to be competitive in the market of the third party affiliates.
I want to confirm that that's the case, Mina, because I'm hearing Commissioner Skinner say that, and I think both she and I have been concerned that it would still allow for rev sharing. I understand. I guess I was first concerned, does it mean some subset of CPAs are decreased? That was my first question. I think I've got clarification on that. But does this allow for revenue sharing, except with the exception of what you?
Sure. So Madam Chair, I'm looking some my own notes a little bit. I found the New Jersey advisory bulletin that I think was discussed a lot during the roundtables, very helpful. And without belaboring it, I want to just go through the categories there. So the things that are still allowed under this, the cost per click, certainly allowed. Cost per impression or cost per view, certainly allowed. Sponsorship deals, which New Jersey defines as gaming platforms pay a flat fee to an entity to be their partner, fine. Cost per action, flat rate deals as a category. Affiliate gets paid based upon a defined user non-gaming action, also fine. That includes sign-up fees, deposit fees, download fees, betting fees, all flat fee. Then they had sort of three other categories. They call this, it's called cost per action, but it's a slightly different cost per action where an affiliate gets a certain percentage of the deposit for every coded user it signs up. And then there's the only thing referred to as revenue share in the New Jersey model is affiliate is paid a percentage of net gaming revenue of a coded user. It's that category that's prohibited, that last one. What is a little difficult because we are not looking at each agreement at the moment to figure out is where that net comes from. Right. And so the reason, so I can't say that no affiliate would have to change their behavior as a result, because right now, during the waiver, that revenue share it is allowed, as you mentioned. I don't know if anyone is doing it. It sounds like at most it's a very small part of the industry.
We might be able to, I wondered if we could find that back out. Because I wondered, I'm turning to Todd now, wouldn't they have to be now seeking that higher license arrangement? Would IEB or licensure be able to tell us if anybody has sought higher licensure?
I'll have to go back and just check on that. That's an interesting question. I'm not exactly sure.
So that would be, Karen, a question maybe for Lilios and Kara, whether or not anyone is seeking that higher licensure so that they could engage in rev sharing. And that might help Nina know like what the arrangement is. Commissioner Skinner, do you want to help me out here?
I can try. I need help myself though, Madam Chair. I think based on the New Jersey guidance, any compensation model that is akin to the three ladder models laid out in this directive, under the current language, those would not be prohibited. Right? Is that, I'm sorry, they would be prohibitive. They would be prohibited, yes. And so anything above that would be okay. So to the extent that there are affiliates that engage in the latter three compensation models, then they under this language, they'd have to adjust their agreements to the extent that that's allowable. They'd have to adjust those agreements to come up with a different compensation model, either the cost per impression or, cost per visit to the site or platform, that kind of thing. That's my understanding. Is that correct, Nina?
Commissioner Skinner, I think that's correct. So to use the easiest example, if their cost per action currently is a deposit fee, and right now they get 10% of the deposit. So if a patron puts in $100, they get $10. And I'm making up raw numbers just for ease here. But if they put in $1,000, they get $100. They could still get paid for deposits, but instead they would have to be in an arrangement where they get either 10 or 100 or 50 or whatever it is, every deposit, no matter the size. And the operator then bears the risk, as opposed to the affiliate marketer, that what they're paying for gets them the deposits that they want to see.
And the difference is, instead of the percentage of net sports wagering revenue, they're just getting paid a flat amount.
Correct.
Set dollar amount. Okay.
Correct.
That's in line with my understanding of how those agreements work. Again, not seeing an actual agreement, just, based on discussions that I've had. Again, I want to go back to the smaller entities that will be affected by a flat out ban on revenue share agreements. And I think this language is a good compromise to allow those entities to continue to compete in the market. My other question is whether there was a reference earlier to the licensing structure, whether we would be requiring a higher license for third-party marketing affiliates engaging in revenue share, or I think, is that the language that exists in the regulation now? If it is, would we continue to require that higher level of licensure, since there is, still, we would be continuing the ban on payment as a percentage of the net sports wagering revenue. So then, if that's the case, is the higher licensure even necessary?
I'm just seeing it may not end up triggering anyone, Commissioner Skinner, with this, because the revenue sharing advertisers are defined in the current vendor regulation as a person who promotes or directs patrons to sports wagering on mobile applications or platforms, or hire someone to do the same in exchange for a percentage of net sports wagering revenue, right? So if it is prohibited to collect net sports wagering revenue, a percentage of net sports wagering revenue, you shouldn't be seeing someone who needs that licensure going forward.
I think we'd have to revise that language, because we shouldn't have anyone, it's not allowed. So, right, the language needs to be adjusted to
correct. And that was anticipated, that this was the solution at the moment in between when you came back to this reg. If you were to take the section 3 out altogether, you would still need this language. If you were to adopt the language before you today, you probably would need to go back and revise 234. It's one of the reasons we didn't add, for instance, in 202. It's actually one of the reason we're holding 202 is, depending on what happens here, we may or may not at a later time want to revise 202 to include those kind of definitions. But one of those will have to change. That's right.
Commissioner Skinner? Alderman?
Yeah, I mean, I think that makes sense. I just, I'll just sum up by saying, I started, I think, this conversation, I think a couple of us did, expressing, uncertainty as to the difference between CPA and revenue share. And, just based on, what I've been able to ascertain over these last several weeks, I don't think that there is much difference. We received, clarification that there's more of an upfront payment associated with the CPAs versus the overtime payments associated with the revenue share. But I think effectively they operate in much of the same way. So I think I'm okay with this language, and I would like to see this language included in the final version of 256.
Commissioner O'Brien?
So Mina, my question is, my only concern with this language is one of the things they also, I think the RG people and the lobbyists made clear is the most sort of predatory and push advertising comes from pay-per-click. And I just want to make sure that we're not rewriting this in a way that incentivizes pay-per-click.
Under this language, you still would be allowing pay-per-click, Commissioner O'Brien. Whether it is a preferable method, I think is a little harder for me to say. Whether that incentive is there. To the extent, there's sort of two things I could say. One is that mitigate that. One is if the pay-per-click violates other portions of this, or excuse me, the call for clicking violates other portions of this reg, then you still have those guardrails there. It can't be unfair or deceptive. It can't be targeted at particular audiences, et cetera. So that's one protection. The other one is the one that is in the works and is ongoing conversation with the Attorney General's office as well, is how data is used and putting the safeguards around the operators being able to get to their third-party marketing affiliates, for instance, data on who may be most vulnerable to a pay-per-click. So those would be the kind of guardrails around it. But yes, as drafted, this would certainly allow a pay-per-click model.
Yeah. I mean, I like the move toward the compromise. My preference is still the original language. If there's a way to rein in that risk, I'm more on board with it in terms of the data usage. I think we've talked about doing this in another reg, putting an obligation on them to use the data they do have to look for signals of risk, et cetera, and to intervene. That to me, going with this language and allowing any kind of rev share for me is contingent on really wanting to make sure that we look at what the data usage is allowed and putting an onus on them also to be more proactive in terms of intervention and RG messaging as we go forward. So that's where I am right now.
Commissioner Mayor, you want to contribute now, or?
I'm happy to. First, I'm glad we officially heard from Connecticut on where they stand on the third-party advertisement. I did say scuttlebutt because I have not seen any proposed regs to accompany those rumors, and I'm always happy to stand corrected. And I furthermore apologize to my colleagues in Connecticut who probably got a few calls just because of my repeating that rumor. Second, I want to go back to what Mina first said. If you're giving tips on the outcome of an event, there should be no remuneration in any way, shape, or form tied to that tip, right? Like that's to me a no-brainer here, right? I just can't. It's fraught with issues from the start. Finally, I agree with Commissioner Hill. I'm okay with CPA moving forward because I believe that it will actually curb the onslaught of general advertisements that people are seeing, and actually will target those who are seeking out information to play in the market or to actually make wagers. But I am somewhat concerned about an unrestricted revenue sharing at this time. Just, a pure unadulterated revenue sharing. I do think that it will probably have some negative impacts to some startup businesses and to some folks who are trying to enter that market. So I think that if we can find some compromise language that will allow them in, and then perhaps look at how it's going, that we may get to the right spot on this reg. Maybe if we have to revisit it even on that piece. We do have to weigh benefits and harms. And, the Attorney General's office cared enough to not only send a letter, but to show up. And they obviously see a harm with this. And so at the end of the day, that's how I'm weighing this, is that, I think that we have to be very sensitive to the fact that if people are being paid by how much money they're driving to someone's door, we should put as many guardrails around that as possible. I don't know who used the word guardrails, but as possible. And, my only, the real issue that flipped me on this altogether on this entire third-party marketing is, two reasons. One is it will help stop the onslaught of general advertisements. And two, it will allow us to regulate those who are in this space. And I'm really worried about who's going to buy the ads if it's not someone that we are regulating and reviewing and watching. So that's where I stand on this, Madam Chair.
Really helpful. Commissioner Maynard. Whether the commissioners want to weigh in? Oh, I guess I'm still sorting things out, so thank you for your patience. I'm reminded, I respect so much the Attorney General's office giving us so much of their time and also submitting the extensive edits, which we've gone through. And I understand their preference, and that's where we started. We did start with, as you can see, and it's now redlined out, but we learned that this arrangement of compensation really does help the good players be able to allow them to compete with the offshore and illegal market. And I wanted to remind everybody of that important part of the discussion. Brianne was very helpful as a responsible gaming consultant to be able to confirm that, that these third-party affiliates that were represented to us and in so many ways really represent the industry in its entirety. Those who are working with regulated operators have indicated that without this arrangement, it'll be hard to compete with the offshore and illegal market because they'll be doing it. They'll be filling the space. The other part I'm struggling with, and is I'm reminded that, and forgive me, I don't have her name, but she was speaking on behalf of Kevin Garnett's association. Mr. Garnett submitted the letter, that she indicated that for their purposes as trying to be able to inform new bettors how to do so in a responsible way and how to understand the gaming world if they're going to enter into it, that will involve small operators, small affiliates. And she said for small affiliates, they're new entrants to the market. They just don't have the, I think they don't really have the patron list to be able to compete with the larger affiliates on a CPA model. So the rev share is the only one that allows them to start to to develop their business. So again, that was why I thought, well, it might make sense for us to have a rev share portion so on behalf of smaller companies, on behalf of MBEs, on behalf of WBs, BBs, just to make sure we don't somehow shut them out. But then on balance, I was also concerned, but if we have the additional licensure, that's another barrier. But we learned at the round table that would be an arrangement that they were used to, and they cited the New Jersey model. So I guess my question, Mina, is, or Caitlin, what language are we operating under right now with respect to CPAs and rev share? Because I'm having a hard time understanding if we're banning rev share altogether or if we're banning a portion of it. And then I would go back to Commissioner Skinner's question, which is, if there is rev share available, maybe you're not speaking about the licensure piece because it's in a different reg, Mina, but I would also, if I heard Commissioner Maynard right, I would probably say if we do have rev share in any form available, I would still err on those additional guardrails.
I'll defer to Mina on the specifics, but right now, because of the waiver, everything is allowed. The CPAs and the rev share are allowed, but that's what we're talking about right now is how to deal with the final reg. So whether it's allowed or not.
So we haven't had any questions from our licensures as to understanding the rev share versus CPA, because we did have the additional licensure requirement.
I haven't heard anything about questions coming through related to this.
Yeah, so that's where what I was trying to understand, Caitlin, if we had given any kind of direction to them, because to understand, was it this language? But we never got to that, right, Mina?
Correct, Madam Chair. So effectively, what's in place because through mid-April, because of the waiver, is what appears on page 10 as a if you were to take just a strikeout language, there essentially be no paragraph 3. The question before you is whether to do that to restore some or all of it, which is the those are the three options.
And so the compromise, this is going to help me. Thanks
Yes.
again for being patient. The compromise language, how does it differ than what we decided when we lifted this?
So when you lifted this for the purposes of waiver, all revenue sharing, all types of revenue sharing would have been allowed with the increased licensure. Now, if you adopt the compromise language, the sort of 3 not struck out, you would not be allowed, you would be prohibiting revenue sharing based on a percentage of revenue where it's a particular user tied to a particular marketing affiliate. You would not ban general revenue sharing, a sort of rising tide lifts all boats kind of revenue sharing, or flat fee payments in a sense.
Okay, so that does clarify everything for me. Very helpful. So from my perspective, commissioners, I would say I'm too uncomfortable with the compromise language, provided that we still have a robust discussion around heightened licensure.
Madam Chair, did you say you're too uncomfortable or you too?
I would be comfortable, but as long as I'm not
Okay.
comfortable yet not taking down the guardrails altogether. And that hasn't, I don't believe that's being proposed yet, right? It's just that we don't have that reg in front of us. But I think we would need to have this conversation again.
Correct. I think Commissioner Skinner's point, that Commissioner Skinner can correct me if I'm wrong, was that some portions of that reg may sort of be a null set of
Yeah, absolutely.
fees going forward, given this language, and I think that's correct.
That's exactly right. Yes.
Sorry, Madam Chair. I think if you take the position that eliminating the ability for affiliates to engage in the percentage compensation model likens them more to a CPA affiliate, if you will, than the revenue share agreement, then I think, it's a good question. Do we need that heightened level of scrutiny? And if we do, I think that would apply to CPA affiliates as well as the revenue share affiliates. Because again, this language just kind of puts them on more of a level playing field so far as compensation goes. That's just the way I see it. And granted, the licensure discussion is a separate one, but I'm just trying to think ahead and really trying to, think of the two together.
Can we, could we see the New Jersey language, please? Because I'm stuck.
You're talking about the New Jersey
Yeah, I don't have it in
sort of
front of me.
explanation.
Can you see
Yeah, give me 1 second.
Thank you so much.
I'm going to make sure I close my inbox this time.
Nobody's looking.
And I think
Well, I understand, but you never, it's, here we go. So I believe you should be seeing now the PDF from New Jersey.
Okay.
So really, this was the categories I was going through. The cost per click, everything is still allowed. Cost per click, CPC or PPC, cost per impression or per view, sponsorship deals, flat rate cost per action. These are the 3 categories I think Commissioner Skinner was referring to earlier that that are implicated by this language. The first one is it's a little bit tricky to say exactly when it's involved or not. Technically, what you're banning is number 2 here, but if the revenue is sort of the deposit from the deposit is part of the revenue, so it's sort of hard to say that they're distinguishable. But in any event, it's these 3 categories where you're talking about percentage based arrangement.
Right. These 3 are what are what?
These are, cost per action, revenue share, hybrid. The hybrid would be disallowed simply in the sense that you would have to do just the flat fee and not have the percentage. You could the issue, the change is that you would no longer be allowing payment based on a percentage of the money tied to a particular user.
So I mean, 1B would also be off the table, right?
It is.
All 3.
All 3 would be, yes. I will
Yes.
say, I don't want to, this is where I might, I find the New Jersey guidance not quite as helpful is, I think the language of number 2 includes within it number 1A and B, if that makes sense. I think that's
Well, 1A, we were defining it as cost per acquisition, not cost per action.
right.
Which seems to be 1A, which I don't think is barred by the rev share.
It's not, well, this is the distinction, Commissioner O'Brien, between the differences. There's sort of different kinds of cost per action.
Yeah.
Cost per acquisition, you see there's a flat rate.
Right.
Yeah.
And
that's why I find, yes, exactly. So I find the New Jersey
Right.
model or explanation of it a little confusing because they distinguish, they still call it CPA, even if it's, or at least as of when this was written in 2014, called it CPA for percentage based of the action. But realistically,
Right.
that percentage is part of the revenue that is being collected.
Right.
Can you show me other examples above where it's rev share? Do any of-
They don't use the word rev share anywhere above. I guess, yeah.
But what we're understanding that there's still revenue sharing arrangements that would be permitted. And I guess I'm trying to understand that based on
Sure.
Mr. Garnett's representative's expectations.
So I'm not sure that this document, at least, Madam Chair, provides one of those examples. If revenue share is meant in the sense that an operator agrees to share 5% of its marketing revenue, of its net revenue with all of its affiliates, or, after it hits a certain threshold. That's a model that exists in some industries. I'm not sure if necessarily applies here. That's a form of revenue sharing, but it's not percentage based.
Okay. And Commissioner Skinner, you would want that to be still require an additional licensure or no?
I think to the extent that those affiliates can be distinguished from the CPA affiliates, yes. But I don't see how. I don't see the difference at this point between the two. The only difference, just based on, again, what I've digested, is when the compensation is made. One is upfront and the other is over time. So is that a distinction that warrants revenue share affiliates being required to have a higher license? I think that's still up for discussion.
I agree. So I guess, does anybody else need the New Jersey language? I'm sorry, but I needed it. Thank you. If we can take it down, unless somebody's still looking at it.
Madam Chair, just before I do, the very quick thing is just to highlight what 234 currently does, and I know we're not talking about the changes to it today. At the moment, the way that 234 is worded, it requires a heightened licensure for this category, revenue share, where it sort of uses the same exact language, and that would now be the prohibited category. So I think that gets back to what
that was my question earlier.
Yeah.
Okay, so that was my question earlier, and where I had asked for guidance that we give them. So very helpful, Nina. Thank you. And I think you had referenced that earlier, the definition, but I wasn't putting it all together without the rec in front of me.
Okay.
So if we're prohibiting it, then in fact, we would just take that out, and then there would be nothing else that we were expecting higher licensure on in any case.
Correct. You could certainly take it out unless you were, and I don't want to get too far down into the weeds of that conversation, to the extent that the comments several commissioners made about guardrails for things that you are still allowing. If you wanted to use that as a guardrail, you would have to shift the language to capture those as opposed to capturing what it does now, which is the thing you're prohibiting.
So commissioners, is it okay if we do shift for that discussion a little bit because it's all wrapped in together? Do you want to go down that heightened licensure process? Does it make sense? Even though I know it's not the reg in front of us, the discussion was certainly integrated when we lifted this reg. How do you want to proceed, commissioners?
So I guess my question is, it still remains on the books. So if we put this language in place, do we have anybody, and maybe nobody here from licensing can answer this question, anybody here who would still need to be licensed?
There's Kara. Good morning.
Good morning. So we do have essentially 5 applicants under the traditional revenue share, where there are net revenues that have signed up for the increased level of licensure. All of the other marketing affiliates that we've received are under our registration level, including the CPA currently.
I do remember having looked at the roundtable too, we had, and I don't know if they ended up applying, but I do know that WinBet said that they would need the rev share. Ms. Roberts, I think it was, who gave that example, but that is part of their work and their arrangements. Okay, so we have 5. And so it would eliminate their ability to do that altogether.
It would, yes, it would. My understanding is that it would eliminate that particular type of agreement, and therefore they wouldn't necessarily need that heightened level of licensure, because even if they are operating under the different agreements, if we take away one of those agreements, let's say they have a CPA with one and a revenue share with another, if the revenue share goes away, they're still operating at that CPA level.
Really helpful input, Kara. Questions for Kara? Commissioner O'Brien?
No, I thought.
Is it appropriate for us to learn about the size of those, or if there are licensee? I mean, is it appropriate for us, or is that because it's under consideration inappropriate? I need some help from legal.
From my perspective, unless Kara or Todd or Caitlin or Carrie, you tell me that the information itself is somehow confidential, I don't think it's inappropriate as a matter of process. In fact, the APA and the processes around reviewing regulations urge agencies to look at the size of businesses affected. So I don't think it's a problem to ask from that perspective. I would just defer to others on whether the information, what information they can share.
Well, if you're asking about the specifics to the entities who have applied for licensure, I think that could be sensitive information. If you're talking about general information as to typically how large these types of deals are, that certainly sounds okay. Obviously, the closer we get to specifics relative to one entity, the more heightened the interest is. But we can look into it. If I'm understanding the question correctly, we can kind of see what the information looks like.
Because I think to Mina's point, we have to vote on the small business impact, but I'm not sure if that's small business Massachusetts only. I don't know.
Well, that's a good question. I don't think the law is that specific as to whether it affects small businesses in Massachusetts. I think it's just in general, but no. So I guess, again, just to reiterate, it's a great consideration, but if we're trying to tie it to the specific operators, that's where it could get a little bit sensitive.
Commissioners, questions? Well, if I understand correctly, then we have 5 who have applied for the heightened registration because they want to engage in the revenue sharing arrangement that our new language would now prohibit. So they would no longer need that heightened registrant. if they were to do, have compensation arrangements that differ from that, they would go through the registrant process in what we have dubbed the CPA arrangement only. What we don't know right now, and perhaps I'm one of 5 who's interested on the impact of the small, but I don't want to speak for anyone else on the small businesses. I'm not sure if how I would proceed. It's 5 out of how many, Caitlin? Do you know how many are going?
You
for
mean
the
Kara?
register?
Sorry.
Oh, I said Caitlin, I meant Kara. You two are right next to each other, and I'm looking at Kara and saying Caitlin, sorry.
So let me just see if I can't see of roughly how many we are looking at in terms of all of the affiliates, so you can get a percentage. My apologies. It looks like we have around 30, not including the revenue share.
So 5 out of 30. If no one else is interested in finding out the size of them, not the details, as Todd, cautions us about that, then I'm fine proceeding. But if it is something of interest, then to the extent Kara can give us that, let's give her some direction. Am I seeing no interest, Commissioner O'Brien?
I mean, if it's something that's relatively readily available, then yeah, I mean.
Madam Chair, if I may, so we're can give care if that is something of interest. Obviously, we're going to need to go through the rest of the reg before a vote anyway.
Yep.
Suggest if that's the only remaining question on this particular section, we could discuss the rest of the reg, and then and I promise to circle back to this, and then if that information is available, we can share it. But if it's not, it's not. But it also, I think, will give you a sense of what else is in the reg that gets at some of the same issues to do that. So, but I don't want to skip any other questions on this, but if that's the only one.
Commissioners, do we want Kara to go through that exercise to help? I don't want to put her through that work unnecessarily. Commissioner O'Brien said yes, if it's not too much work, if it's available. Commissioner Skinner?
The specific information you're requesting is the number of small businesses that have registered or applied for a license?
No, I'm asking about the nature of the 5 that have triggered the heightened.
Okay.
See, are they big businesses or are they small businesses? And we do have that obligation to vote on the small business impact. So I'm thinking about that piece of work. But I also don't want to be if I'm the only one, but Commissioner O'Brien is suggesting if it's not too onerous, and then we can move on.
Yeah, I'd like to take a look at that information. It would be an interesting data point.
And if I may, specifically, we're looking for the essentially the size of the business in terms of employees. Do they identify as a small business? Things like that. Okay. I'm not sure that we have that information on file, but I can certainly look and report back.
Thank you.
Madam Chair, that's kind of my worry is who's defining small business versus medium-sized versus large business, and how's Kara going to pull these? That's kind of what I'm sitting here thinking. It sounds like an interesting task without identifying who they are, especially in a public setting. How can we get this information?
Is there a way to see if any of them are MBE, WBE, VBE, and or sort of the range of employees? Like, do we want to know if they have greater than 50 and do any identify as any of those, you know?
I
businesses?
will, oops, sorry.
Oh, go ahead. I was just thinking there might be a way to narrow it, maybe to get some of that information as a data point.
So I do not yet have the applications memorized, but I do believe if they are minority, women, or veteran-owned businesses, we do ask for those certifications. So I can certainly take a look at that.
Very good. So it's 50, is that what the Secretary of State asked us to look at, Tom? 50 employees? What's the net for small
I
business?
threw that out there as a
I wondered, yeah.
Yeah, I don't know that there's really any, to Commissioner Maynard's point, I don't know that there's any official definition of what a small business is, per se, and that's what makes it difficult. But we'll take a look. And
Oh,
I know, well, there's a lot of nuance to that question, but the law itself, I don't believe defines it. I know the executive branch over time has come out with different definitions and things like that. But, I think, why don't we maybe give Kara an opportunity, and I can check in with her just to kind of see what we have and try to call out whatever information might be helpful to address that question.
thanks everyone for your patience. I feel that it's just a piece of impact. I want to make sure that I understand it and that's not, that somehow we're not inadvertently impacting them. So thank you. All right, let's move on. Unless there are other questions for Mina, I'm the one who's held everybody up. Okay, let's go.
Right, thank you, Madam Chair. So I will move on to 256.014, a little bit of new language here. Some of the language the language that was added here was following the comments and follow up with the Attorney General's office. As I mentioned, part of their concern is transparency with the relationships between folks doing marketing or advertising and operators. So this language is intended to be a broad statement that if you are going to advertise or promote sports wagering, you need to disclose. The way we worded it for this purpose is whether a financial relationship exists. So we were cognizant of not wanting to necessarily have every ad explain this is how this endorsement deal is structured. That may be too intrusive, but to make sure that if someone is going to be speaking or promoting a sports wagering operator, that it's clear that they are if they have a financial relationship with them.
I like
Brian?
I like the language. I think it's a step in the right direction.
Any other input? All set? Let's continue.
256, thank you, Madam Chair. 256.021, the new language here, this was one of the questions that I believe we had following Thursday. I just want to confirm with the Attorney General's office, the concerns regarding whether to reference 93A and other consumer protection statutes specifically or by inclusion as sort of all other laws. We agree that referencing all other laws makes sense here. We didn't want to accidentally omit anything, but we did add language at the verbal request, although they had not reviewed this language, specifically specifying that not only do you have to comply with all other laws, but that this is not intended to supersede or replace any more stringent laws, which is a concern born out of 93A defense practices, I believe, that have come up over the years. So we think that issue is now addressed sufficiently.
Any issues with that, Commissioner? Okay.
Thank you. That's an issue only lawyers could love, so I'm happy to go through it quickly. 256.044 on page 12. This language has largely been in place. There were some tweaks to it. Again, one of the core concerns from the Attorney General's office reflected in a few places, excuse me, is the issue Commissioner Maynard touched on a few minutes ago, the idea that an entity that is involved in marketing could also be giving advice. A couple of things here. One was making clear upfront, especially with increased focus over the last couple of weeks on third-party marketing entities, that whether that they are part of what's referenced here, those required to be licensed or registered pursuant to 234, as well as any other sports wagering vendor. So we included that here. So that's really just a change in the category of who's covered. And the suggestion to remove the word individual, that was actually not a specific recommendation from the Attorney General's office, but it is something that we are recommending from the legal team for two reasons. One is this is a portion of the language that prohibits an entity from giving advice on what bet to place. It does not prohibit, and this was language we had added and talked about Thursday, it does not prohibit, hey, the Patriots are playing tomorrow, that would be a thing you could consider betting on. It would prohibit, the Patriots are playing tomorrow, you should bet on the Pats. So that initially was limited to an individual. So it would be a targeted ad or an ad a sports book, an employee saying that to a patron. The reason we're suggesting removing individual is that the concerns we heard from the Attorney General's office, as well as in the discussions here, seem to be focused on the practice in general of advice giving, and other measures, as we'll get to as we move through the reg, that attempt to get at that same behavior. For instance, what can and can't be said in a sports broadcast, and regulating it that way are much more difficult to police and enforce, whereas a clear expectation up front that sports operators and their vendors, marketers, et cetera, should not be engaged in the giving of advice is a much clearer standard in our view. So that's how we would like to suggest addressing that broader issue, is removing the word individual. The other piece of this, the other additional language at the end of this, I'll just cover and then open it up for discussion, is a slight tweak. I think there was a request from some of the operators to make sure this, like I said, does not bar the, there's a Patriots game tomorrow, a Celtics game tomorrow that would be worth betting on, it will be of interest to you. That's not restricted. And also they wanted to make sure that if there was a particular promotion that required certain terms, their obligations to be transparent about what is needed to do to meet the promotional offer, and this restriction didn't conflict. So we made that clearer here. So it would not be prohibited to say, and I should be the last person to make up any promotion, but if you bet X, you could win Y. That does not get misconstrued as we advise you to bet X. So they just want to be clear that they're able to still do that information giving if it's not advice giving.
Any questions? Let's move on.
All right, thank you. The next section is at the end of 256.04. This is 256.04, 6 new L on page 13 of your packet. This is similar to the last concern, also came from the input from the Attorney General's office in part, although I will explain what we did and did not take from it. The Attorney General's office, again, is concerned about individuals providing purported expertise or seeming to be experts in, having some inside knowledge that then gets translated to to a patron as sort of better advice because of who it's coming from. So that is listed in the prohibited or limited activities. The Attorney General's office had encouraged sort of a slightly different language, or suggested slightly different language, that both captured one, individuals affiliated with teams, clubs, etc. They had not used the term sports governing body. We did, because I think we're familiar with it as opposed to just saying leagues. They also had suggested sports broadcasting networks where there may be a tie with the team. That language, as I mentioned a couple of minutes ago, seems to us to be more difficult to enforce and to police. However, with the change above that you just heard about, we think the message is clear to operators that they should not and cannot be sponsoring, for instance, the giving of advice on the placement of a particular bet in one direction. And so we are comfortable that the intent here, that this sets up adequate guardrails without some of the enforcement difficulties that might come up with just tweaking this language.
Madam Chair, can I just ask Mina something about this? So Mina, just so I'm clear about it. So for example, locally, we have Nesson, which is owned by the Boston Red Sox, or that ownership group, let me say that. And they have on their channel shows that have folks come on and suggest how people should bet moving forward, not necessarily on the Red Sox, but whatever the game of the day is. How does any of this affect that? And Sportsnet has also has shows on.
It's a good question, Commissioner Hill. The way I would think about this is, if you go back up to the language of and who's within your jurisdiction in the first place. If an operator is using that platform, if that show is, I won't single out operator X's show, or they clearly are then compensating the network for doing that, that may trigger this problem, right? Because they are paying through someone who is working on their behalf to provide advice and to provide input on what you should bet. And the concern there is that a member of the public, especially if they don't know that how the particulars of that relationship, there's sort of an inherent temptation, at least for the operator and the marketer, to make more money by getting bad bets. However, on the other hand, if it is simply a show that is being shown by Nesson, and Nesson is not the money is not coming through the operator to them, it should not capture that, because that is sort of a broad statement. I think each operator and each broadcaster will have to determine where the line falls. We intentionally used in the new section 256.044 on page 12, the language, a third party marketing or advertising entity required to be licensed or registered. Generally speaking, under your vendor registration regulation, 234, broadcasters are not considered that unless they're engaging in more direct, partnership advertising directly, right, as a vendor. So in other words, if the Nesson host or show, or Nesson itself, is acting like a vendor, then it may fall under this. If it's acting like a broadcaster, it should not. the so and again in L, this provision we're talking about now, this is again all under the umbrella of no advertising, marketing, branding, et cetera, the normal list, by or on behalf of any sports wagering operator shall use individuals, right? So there is this sort of limit there too, that it's one thing for NESN to even have a show about betting on baseball. That may be one thing if NESN and MLB are okay with that, and the Red Sox are. On the other hand, if it's an operator or a group of operators on their own behalf paying for that show to run, that would be an issue. Or in the purpose of that show saying the best line today is on operator X's platform, I think you do have a concern there too. And so, but neutral advice, here's what we think is going to happen, who's going to hit a home run, who's not, how the Red Sox are going to win 90 games, et cetera. So.
No, that clarifies it for me. Thank you, Mina. Thank you, Madam Chair.
Thank you. Any other questions? Okay, let's move on then, Mina. Thank you.
Thank you, Madam Chair. 256.05 A and B, they're related, so I'll just take them together. This is a slight tweak. We have provided some language. I think we described it, Christina and I described it on Thursday as, at the time, our sort of best effort at what we thought the Attorney General's comments would say in light of having their red lines. We tweaked it a little bit further, and we're trying to capture the best of both worlds, I think, as we were describing it. So there's sort of a two-part here. This has to do with media outlets and youth-related or underage-related sports wagering. Prohibition, obviously. For in media outlets where 25%, which is the standard you've been using, of the audience is reasonably expected to be underage, you simply may not market unless adequate controls are in place to make sure that the underage folks are not seeing those ads or not getting the ads. So that's if you believe or if you have reason to believe a particular social media platform or television program is targeting underage individuals, then that is the limitation. You basically have to be able to show that you're somehow keeping it out of that out of view. In all other media outlets, the requirement within this is the language from the Attorney General's office. The operator needs to use all available methods to exclude underage individuals, but this one is sort of understanding that there may be a feasibility limit. And this is a distinction I believe I was getting at the other day between, for instance, a generally available television program like a sports broadcast where some amount of underage viewers are expected to see it, but it is not targeted at that audience. It's not expected to be more than a quarter of that audience. All available methods should be used to limit, but it is understood that there still may be some exposure, whereas in media outlets that target or that whose more than 25% are underage in the audience, you do need to exclude it altogether if you're going to use ads on that platform.
Question, Commissioner O'Brien?
So Mina, we seem to be using, like if you go down to C, it says where 25% or more of the audience. Are we missing the or more in A? You could just say we're 25%.
Yes, I'm sorry. Yes, certainly. Yes. Yeah. I would not want someone to say, we got 26%.
We have 26.
Yeah, no. I'm sorry. That is, yes. Thank you for that catch. It is 25% or more is the intention there.
Okay. No, I like it.
I really like it too. I was just going to say the same thing, Commissioner O'Brien. Yeah, I think I like how it's distinguished in this reg here, A and B. Very, very strong. Commissioners? Okay.
All right. Madam Chair, 2560662 This is on page 15 of your packet. There's not really much of a change, but I highlight it because I think we were not, done with the conversation after Thursday. So I just wanted to make sure the final wording was what the commission would like. This has to do with the what language is required in advertising. As worded right now, let me just describe what it does, and then I don't know if Todd or Karen or others have any further input on it.
Executive Director Wells too will be addressing this if you recall.
Okay, great. Yeah. So as worded on in your packet now, the commission would retain the authority to adjust the responsible gaming messaging over time, and it could include a combination of things. It could include problem gambling helpline language provided by the Department of Public Health, and so let's call that A. It could include just that. It could include that plus additional messaging from the commission that it wishes to use, or just separate messaging from the commission. All of those A plus B, or just B could fall under the gambit of this. It does not tie you to any one of those positions by regulation. That's not to say that you would, it would sort of allow you with further consultation with DPH to continue to refine what makes sense for the marketplace. So Director Wells or Todd, if you have anything to add.
Karen?
So Commissioner Skinner requested at the last meeting that we reach out to DPH because I identified their concern about adding language beyond just the information provided by DPH. They're not going to be coming today. They would require going up the chain and authorization, so we don't have that for you today. So, the way things stand, as I indicated at the last meeting, that had been a request. I did review for Mr. Ortiz, who is the director of their responsible gaming program, that the statute requires on the platform that the number for the DPH hotline and their website be on the platform, but that the statute is silent with respect to advertising, and that commission's working on that through the regulation, but that authority vests with the commission. So from an operational standpoint, we just need to know what to tell the operators that they need to put on the advertising, because we're getting questions and they're advertising, and we need to make sure that there is a clear message about what the requirement is, so that we can enforce if there's an issue. So at this point, it would be helpful, A, for the commission to make a determination on the language, and then also to give us some feedback, because the way this reads, the or, it does say or such other responsible gaming information required by the commission. So it seems that the commission would have to sign off on what language we would communicate to the operators needs to be on their advertising, and what advertising, because part of it is billboard different from print media or some other types of advertising where there may be more space. So, and I think Mark is on as well. So if you have any questions for him, we can ask him as well. Hey, Mark.
Madam Chair. So just to be clear again, and I'm sorry, I only have one screen today, so I have to pop back and forth from the language to the screen. So bear with me. So Karen or Mark, as I understand it, with the new language that's being proposed in the highlighted area. So it says provided by the Department of Public Health or such other responsible gaming information. Now, the Department of Public Health is mandated, as you just said, on the platform, their phone number, correct?
The phone number and the website, yes.
But not on an advertising, so on a newspaper or my Facebook or things of that sort. I wouldn't necessarily see that. Is that accurate?
Well, the commission is not required to do that. Obviously, there is some value in the hotline number for people in crisis, so that may be something that the commission would want to have on every piece of advertising, but it's the commission's call what's going to be required on the advertising. You're correct.
So let me just, Madam Chair, if I may, I want to offer my insight as to what I would love to see on all platforms, advertising, things of that sort. And I want to preface this conversation by saying we have 3 entities that are helping us in this endeavor. We have DPH, we have the council, we have GameSense. That's just my thinking, 3 prongs. And all 3 are great at what they do. And all 3 should be working together to ensure that when a phone call comes in, whatever that number is, we know what it is, DPH, that a conversation is taking place not only with DPH programs, but with council programs and GameSense programs. I don't know if this is happening, and I'm only surmising that it could be happening where, and I've been in this game long enough to know there's turf wars. And I don't think we have a turf war going on, but I want to make sure whatever our language is, that we're not creating a turf war, but that we're all working together. What I envision, which is what I saw over the weekend by one of our operators, is I saw the 1-800 number, and at the very end, I saw a GameSense emblem. I would assume, and I think I heard Karen say at one point during a discussion that there could be confusion between the 1-800 number and GameSense. I hope that's not happening, but if it is happening, I would hope that whoever is at the other end of the 1-800 number is explaining what GameSense is. If somebody is calling about what's the GameSense to the 1-800 number, which is the DPH number, 2 different entities. So I want to ensure that whatever language we do come up with, that we're working all 3 entities together. If one should get a call, that's not necessarily going to, like, for example, the 1-800 DPH number isn't GameSense, but I want people to see the GameSense because it is so important to what this commission has been doing clearly before I got here, but since I've gotten here, the great work that they're doing.
Commissioner Hill, could I just ask Karen to remind us that the word confusion first started, I think, when Director Ortiz brought to our attention language on the platform. It was on the platform, Karen, where there were a couple of phone numbers. There was language about DPH, language about GameSense, and 2 phone numbers, and there was confusion over that. Then I think, Karen, you may have used the word confusion again with perhaps, I don't want to attribute it to Mr. Ortiz unfairly to him.
Right.
But I want to make sure that I heard confusion initially because we got the operator's language. So then Mr. Ortiz presented a proposal, which I think today he's not here because it hadn't necessarily been vetted fully or something. I don't know if I understood that correctly.
Correct. So, yeah, so that's why I want to be careful not to speak for Mr. Ortiz or speak for DPH, because I want to make sure they present their ideas accurately. But the concern was sort of mixing messaging, is that, and there are distinct components. And Mark can explain. There's the value in what DPH is doing and how it differs from what, for example, voluntary self-exclusion and the approach and how they complement each other. And I think both DPH and Mark are in agreement that they're complementary type of endeavors. But Mark, I'll defer to you the difference.
I'd like to just set the stage a bit more, Karen, because again, in the reg as proposed now, the commission would be able to determine responsible gaming messaging. Commissioner Hill. So at the end of the day, we can give direction. And I think what you and I see, because I think I see the same billboards, really is that clear phone number and the game's logo. But I think Mark will explain that he's proposing some additional language as well to the numbers where it's appropriate. I think billboards are unique because of the size of the font and that real estate. But I think you and I are in agreement. We see those two things really pretty clearly on many of the billboards. So Mark, with that, and again, you did a really good job the other day explaining the distinction. It might be helpful to repeat that, and just because we've had a lot to think about. So thank you.
Sure.
And social media, Madam Chair, not just the billboards.
Well, yes. Oh, absolutely. Yes. But it's all messaging, advertising through social media. The real estate piece where it's limited to that is, I think, Mark, correct me if I'm wrong, but addressed pretty much just in the billboards issue.
Okay, I can, thank you, Madam Chair, and I'll do the best I can here, but please feel free to ask questions. So there are currently two numbers that are out there. I completely agree that we need to be clear, and if we can whittle our way down to one number, that would be the best case scenario. But there are some challenges here, and but I think we can get there. So the Massachusetts Problem Gambling Helpline, I'm just going to say it's the number that ends at 5050. It provides information about, up-to-date information about problem gambling resources, treatment, community-based resources that are available in Massachusetts. The other number, the GAM line, which I'm going to say it ends in 1234. Originally, years ago, it was the problem gambling helpline, but when that contract changed from DPH, it was rebranded as the GAM line, and it became the number that primarily people use to enroll in the voluntary self-exclusion program remotely. And during COVID, it was very important for people to be able to enroll in the voluntary self-exclusion program through a remote process, and certainly with sports wagering, mobile sports wagering, it's important too. But the 1234 number, in addition to enrolling in the voluntary self-exclusion program, it's operated, answered by GameSense advisors 24/7. It provides information about responsible gaming, including, they know each of the operators' platforms and what responsible gaming tools are available, and can provide information to people about how to control their gambling if they're not interested in the mass problem gambling helpline and the services or the connection to community-based resources. If people are interested in community-based resources through the 1234 number, there's a warm handoff that can happen to the Massachusetts Problem Gambling Helpline. And that's a really important piece, that warm handoff, that if somebody wants to get community-based resources, they can. One of the challenges that we have, though, is that while the Mass Problem Gambling Helpline will refer to community-based resources, a conversation that we had with Victor Ortiz is that they weren't really referring to the voluntary self-exclusion program. That's a hurdle that I think that we would need to get over. When somebody's looking for help in addition to community-based resources, perhaps they're not quite ready to move in that direction. Perhaps there's something else that they would like the voluntary self-exclusion program, like play management settings from one of the operators' platforms, or cooling off, or a host of other things. I think that the full spectrum needs to be there. So, if we can get over that hurdle, and perhaps if we can get over that hurdle, I think that we would be okay not promoting the 1234 number on advertising, but that there needs to be assurance that people can easily access the voluntary self-exclusion program and the knowledge and information that GameSense advisors offer if that's what the individual would choose.
So Mark, you had told me that you had a recommended tagline that we could perhaps use as reasonable, responsible gaming messaging for the purposes of this reg.
Well,
What would you recommend today for us?
well, so my recommendation would be that if that the commission retain the authority for the messaging, that we would use the Massachusetts Problem Gambling Helpline, but that we would engage with DPH to assure that there is appropriate information available about voluntary self-exclusion and about the resources, responsible game resources through GameSense. That we would, in terms of GameSense tagline, that it would stay very brief and very short with the GameSense logo, play it smart from the start, GameSenseMA.com, just the website, not the phone number. I want to reduce, I agree, we should really only be promoting one number that would be out there. And that in terms of the
Could you
public
give that
gambling,
to me? Could you just say that language? Well, if the commission directs responsible gaming messaging language today,
play
what
it,
would be your recommendation for today? No conditions attached right now.
it would be play it smart from the start with the GameSense logo and the GameSense website.
And not include the DPH's number?
No,
Could you just
there-
say
there
the
would also-
entire, yeah, everything, the whole,
well,
what
I
would
would
be,
need,
because responsible gaming messaging could include the 1-800 number under the way messaging, the reg is set up. So what would be everything that you would recommend?
Madam Chair, I don't know if I'm ready to make the recommendation, in part because I would want to work with the Department of Public Health to make sure that it's a tagline that works for both entities. And I haven't done that with DPH or with Victor or Pease.
Director Wells?
Mark, I guess the question is, I think there's 6 pieces. There's for DPH, the 3 pieces. There's the phone number, the website, and their tagline. And then there's the Gaming Commission logo, website, and tagline. So those are the 6 components that we discussed. So I think that DPH provided what they wanted for a tagline. Is that correct, Mark? I think, do you know offhand what that is? I can look it up, but.
Well, no, I do have it right here. And the reason why I would say that we would want to work closely with DPH is that in my work with each of the operators, the tagline, even if we just use DPH's tagline, it would be quite long. And so we would need to work with DPH to be able to shorten it, but get to the point.
Madam Chair?
Yes, Commissioner Hill.
So over the weekend, I already said this earlier in my comments, I saw one of our operators put out an ad on TV. And at the bottom, it said, "Hope is here." It's the gamblinghelpline.org or call the 1-800-327-5050 for 24/7 support. And then at the end of that is the GameSense emblem. And as I was reading this is exactly what I would envision that we would see on an ad moving forward. But I'm hearing Mark say that we also need a tagline for GameSense. But that's here nor there at this point. We need to talk that out with DPH on what we would want to see moving forward. But in that particular ad that I saw, I get a website, I get a phone number, and I get a GameSense emblem, and it looks awesome. So as we're reading our regs today, how does that continue to happen?
I think, Madam Chair and Commissioner Hill, there might be one point of clarification though, because unfortunately the emblem isn't going to give an access point to GameSense because the 5050 is not going to direct them to VSE or GameSense. So without a website on there, I think part of the conundrum is as it stands, visually it might be satisfying, functionally, it doesn't get you over to the VSE and the
So
games.
with my comments earlier, understanding that, my hope was that if someone calls, what's Game Sense? That we're going to have a great conversation taking place, but I understand that may not happen.
Right. And so then the canonical, what do you do? You know, is there a way to put the website on there such that there is an avenue in while that's being worked out?
I agree with Commissioner O'Brien. What I'm hoping for today, because Director Wells has said, our operators are looking for immediate guidance.
Right.
So I know that, Mark, ideally you would like to have, meet other conditions, and those are conversations that should be going. And I think Director Wells has indicated that, they're underway. DPH couldn't make it today. Commissioner Skinner had, it was the right request to ask, and they just couldn't be here. So, Mark, I think that you had kind of a tagline that might help get both the DPH, what was the immediate phrase, Commissioner Hill, that you read? Hope is here, right? Hope is here.
But Game Sense has another tagline.
Right. So hope is here. Yeah. So hope is here in the phone number and their website, and then our tagline, right, with the website. It would still be a lot, but it would be clearer, maybe. But what was your? I know that you. Yes.
Can I ask one other technical question?
Yeah.
But this would only work for social media. It wouldn't work on a billboard. It wouldn't work on a newspaper ad. But is there any way that if I'm on a social media that I can click on the gambling helpline, or I can click on the Game Sense and it brings me right to Game Sense?
That's why we should use that. What is it called, Mark? The Q source, right?
I'm sorry, say that again, Madam.
What is the
QR code?
No, yeah, so everybody can just take a picture of it, send it directly to us.
Yeah, and Madam Chair, I think that is absolutely something that we should explore, how we would use that, how it would be integrated. Definitely, I like that idea a lot. In fact, I had a conversation with somebody on Friday about what that would look like and what it would lead to. So I would like to pursue that. Yeah, I mean, Madam Chair, I did pull up. So the current guidance that exists with operators is it's either hope is here, or if you or a loved one is experiencing problems with gambling, call 1-800-327-5050 or Game Sense or gambling helpline ma.org for 27 cents. For the Game Sense, let's see, it's play it smart from the start, gamesensema.com. And then it was the 1, 2, 3, 4 number. I want to use one phone number. I want it to be a one-stop shop. If you, no matter what you want, I want there to be information that you can get to where you want to go. I think that I believe that would be DPH's desire as well. I'm sure that's the desire of our commission. But how do we? I think it just will take a little bit to get to that point to make sure that is happening.
So it sounds like.
I'll be clear. I thought that it was happening and has been happening over the last year, and I've learned that it wasn't. So today we have to make a decision. And Commissioner Hill, what are you thinking in terms of the language?
So I think, Mark, you just put it all in a nutshell for me. I want to be able to call one number and get as much information as I can possibly get with the community-based resources and Game Sense resources. How do we get to that point? But that's I guess from what I'm hearing now, that may be an ongoing discussion. For today's purposes.
And a reminder, Commissioner Hill, that in the statute,
correct,
to avoid confusion, the operators on the platform must use the DPH number.
Correct.
As my understanding is, there was a procurement that was done for this number and for these services. DPH works with another organization to have that 1-800 number. That is in the statute for the operators. It's just not in the statute for advertising. And our regulation, as written now, really allows us to retain discretion over what should be responsible game messaging for right now, but we could tweak it because I assume that this would be something that we would just do by policy, right, Todd? Responsible gaming messaging could change in October or in August if we gave Mark direction at a public meeting, what it means, right?
Yeah, I think that's right. I think we just want to have clear direction as to the commission's intention.
For today.
Madam Chair, may I just express one question about the way that it's currently drafted? Is that it calls it responsible gaming message. And if you talk to DPH, if you talk to the helpline, they would not define that as responsible gaming messaging. They would call it problem gambling messaging. There is a clear distinction between the two.
So, Madam Chair, just on that, that is a term we try to create because it comes up in a couple of places. You'll see a reference to problem gambling helpline or other responsible gaming messaging. Frankly, we could tweak that term if the commission feels it's appropriate, but it's really just for the sake of being able to repeat it in a couple of places in the advertising reg. So that's, we don't mean to limit by any means what could go there in that section.
Commissioner Hill?
My mind is turning, Madam Chair, and I do see Commissioner Skinner wants to add something, so maybe.
Well, thank you, Commissioner Skinner. Thank you.
Thank you. I understand and respect Mr. Ortiz's limitations in not, in an appearance today, but I was really hoping to engage in a dialogue, a meaningful dialogue with representatives from DPH so that we can collaborate and cooperate and come to some mutually beneficial language to direct the operators to include in their advertising. Like a couple of you, most of you, probably all of you, I am a little disturbed by the fact that there is not a referral process in place at DPH for individuals that they come across who might be in need of GameSense services, requesting to be put on the VSE. And it's my position that they shouldn't have to request to be put on the VSE list or request information about VSE services. If there is, if DPH is the access point for individuals who may need further services and resources to address an issue, that is information that I believe, the GameSense information and VSE information, that's information I believe that should be readily pushed out to those individuals. And, I am, again, disturbed that that's not already being done. Commissioner O'Brien referenced the access point, and that's missing right now in what Commissioner Hill observed over the weekend. I do think that that is important. We do need to be, we need to be able to receive information, those patrons who are looking for something more than what DPH has to offer. And so I would be looking to have at least the contact information on the GameSense, for GameSense in the advertising, in addition to what's required on the platform. I think we have the statute that speaks only to the platform. I don't think it's a bad idea to have the DPH problem gambling hotline on all of the advertising. I just think that the key is going to be a mutual agreement between the two agencies so that each agency's interest is addressed. And really the interest of the general public and folks in need of assistance.
Thank Thank you, Commissioner Skinner. I think I'd like to point out one thing, and I don't have, and Mark, we've had a lot of discussions about this. The VSE, when Game Sense, our materials hand out, what number do we give them for VSE?
If you want to enroll,
on the Game Sense and on the floor, if they call online, what number do we give people seeking to be on the voluntary self-exclusion list?
it would be the 1, 2, 3, 4 number for a remote enrollment. And right, and if I actually just received some data from Long, about half of our enrollments at this point are remote enrollments coming in through the 1, 2, 3, 4 number.
Right. So we don't give the 1-800 number to them. Just one minute. We don't, on our VSC materials at GameSense, we don't give the 1-800 number. We give the 1-800 number for problem gambling, but for specifically for VSEs, we give the 1, 2, 3, 4 number.
Correct. Right. If we listed the helpline, it wouldn't be channeled through there. We do provide the helpline number in a variety of ways.
Yes, we absolutely do, and that's on treatment. But I guess I just want to make sure because, you know, Mr. Skinner's pointed out DPH isn't here. I do think I had understood when the number changed that there was a center and everything was going through the 1-800 number and then going directly to GameSense advisors. Somehow I missed that the 1, 2, 3, 4 number was still being used. And I learned this just during this discussion, that in fact, the 1-800 number is really where we refer folks for gambling treatment, but to Mark's point, they also need to be able to refer to VSEs. And I do know that DPH has engaged in VSE training because Mark's and his team has arranged for that. But somehow, and they may not be making as many referrals to VSE that we would anticipate. And that's what I think needs to be clarified. But in the meantime, we should all know that there's another number that is being used, and that's the council's number for VSEs. And that's how all of that is going. So I think that's a really important clarification to understand that, you know, the swarm handoff, that, and I think of it as a technical issue more than anything else about telephone numbers that they should be forwarded. That may not be happening in the way I certainly understood, but I guess I just want to make sure that, you know, we recognize that there's continued collaboration and clarification that needs to happen here among the three entities, which Commissioner Hill, you set the stage beautifully, saying everybody is working hard on these issues. So back to today's issue, Commissioner Skinner, I appreciate too that we don't have DPH here, but I'm wondering if we can we help Director Wells out today, or do we need to wait till Wednesday for this? But I do think we need to give the operators clarification because they're looking for it, and it is for the commission, us, the five of us, to decide and give Director Van der Linden guidance. So where are we?
So can I ask one last question on the language, Mina? And I know this was brought up the other day, and I know in the legislative speak, a shall or a may make a very big difference. So tell me the difference between an and or an or in this particular case, because I think what I would like to see is an and, not an or. But tell me why I'm right or wrong on that.
Sure. So the or, which is what it has now, allows for the commission to choose to include the problem gambling helpline, any additional messaging the commission wants to add to that, or just the additional messaging the commission has, and not to include the problem gambling helpline. The and would require the problem gambling helpline as a minimum, and any other additional messaging, if any, that the commission wants to add to that.
Nina, can I just interject just to clarify, because I'm just reading the language. The first part requires the helpline, I guess the link, which would be the website and the helpline. But it does say using language provided by the Department of Public Health. So it seems to me that first part would give the Department of Public Health by reg the sort of the say in what the tagline is. And then
Correct.
Right.
For the helpline and the link, correct, yes.
correct. And then it's the and the or. Okay.
But on the latter phrase, it doesn't mean that we couldn't, however the language we use, the defined term of responsible gaming messaging could include the first clause.
Correct.
And I understand Mark's distinction saying, well, responsible gaming doesn't typically include problem gambling treatment. So maybe we could come up with a different defined term, or just, keep it responsible gaming messaging. Commissioner Skinner.
One of the things that we've talked about in the past, but it didn't come up today yet, is the confusion factor. Having information from both entities, and depending on how much information, if we're talking about those 6 points, Karen, the website, the phone number, the tagline for DPH, and all 3 for GameSense and MGC, it is going to be confusing to a patron, or potentially confusing to a patron. And I know we're being asked today, Madam Chair, to make a decision, but I don't know how realistic it would be to do that without having a visual of what, whatever recommendation Mark comes up with. Does it make sense to, have something prepared so that we can see it, to see what, effect it might have on that confusion factor? I'm just, I want to make sure that we're thinking about this practically, and it's kind of hard to envision what something might look like with all 6 of those points, six of those pieces on an ad without actually seeing what it looked like, because that's a lot of what it looks like. Excuse me, because that's a lot of information.
Director Wells.
Yeah, so it may help to sort of to narrow this a little bit. Now, it seems as if both DPH and Mark are indicating that the DPH 50/50 number should be there. Is that right, Mark?
Yes, there should be. I would limit it to 1 number.
So DPH phone number, and then also the DPH website. Should they have the DPH website on the messaging?
Yeah.
But
yes.
Okay, so there's 2. So then, putting the tagline aside, my understanding, your position was that what would be helpful was the GameSense logo and the GameSense website as well.
Yes.
Is that your recommendation?
Correct. It would be great to have the GameSense tagline in there too.
Okay. But at a minimum, sort of for the actual information would be the DPH number, the DPH website, then the GameSense logo and the GameSense website. So that's sort of the bones of it. And then what it sounds as if we're trying to figure out what's the tagline. Is it 1 tagline for both? Is it 2 different taglines? Like how do you work that out? So that's what I'm hearing is where the sort of the decision point is. But I don't want to speak for the commission, because any one of those 4 things you have the discretion to do what you want for advertising. For example, Mark had indicated for billboards, you saw billboards differently than the other. You may just want the phone number and the GameSense logo required on billboards, but other advertising, you might want all of these. So I'll defer to Mark on that.
Right. I mean, it's one of the key pieces of GameSense has been increasing brand awareness. You drive by a billboard and it's difficult to pick up too much information, and we've held that as long as the GameSense logo is present, that would be fine for me. I'm fine. if I could just go back, I really agree that there should be one number here. I just want to make sure that there's adequate, that if there's one number, there's a warm handoff to a game sense advisor to do, or to, you know, game sense advisor to do voluntary self-exclusion. And that warm handoff, what that means is either on a phone tree, you're pressing 1 to be connected to somebody from the Massachusetts Problem Gambling Helpline for information and resources for treatment within the community, 2 to enroll in the voluntary self-exclusion program. Or when you're talking with either a game sense advisor or a helpline specialist, that you can have a warm handoff, meaning a direct transfer to somebody from one of those resources.
So then it would be anybody for a VSC would go to the 1-800 number and then be transferred. And then the 1-2-3-4 number would no longer be used.
It would well, I mean, it would work in the background. I mean, you could still.
Oh, but after it goes, but everybody would go to the 1-800 state number, DPH number. And then if they're seeking VSC, there would be a warm handoff, to use your words, to make sense. And then for problem gambling and other services or treatment, I mean, then that would be DPH, but DPH would have the technical mechanism to transfer right to the council's game sense number, game sense.
For the purpose of I'm definitely for the purpose of advertising and the disclaimer that happens on any advertising, I would support that it goes to the 50/50, the Mass Problem Gambling Helpline, as long as it's really clear that people are able to easily access the voluntary self-exclusion program. Ideally, that happens through a phone tree, much like it happens on the 1-2-3-4, the council's line right now. Press 1 if you want to be connected to the Massachusetts Problem Gambling Helpline. Press 2 if you want to be connected to a game sense advisor. It's a way to assure that people are triaged to the service that they need. And even if they're not, if you're talking with a game sense advisor and it should be transferred, they warm transfer it to the Problem Gambling Helpline. I want to make sure that there's easy flow, that you can call this one number and you're assured to get the information that you need.
But Mark, can I just clarify, but the commissioner, we can't assure the commissioners today that that's going to happen today or tomorrow. That's sort of a project. So I guess my question is, are you recommending today for us sending, what's your recommendation today, that we still just do the 1 DPH number? You're not recommending we put both numbers on the thing today. That's what I'm hearing, but
right.
I hear what you're saying. You know, in the ideal situation, we work it all out before anything gets launched, but we're just not in that situation, and we need to prioritize what's best for the public. So
I don't want somebody to fall through the cracks right now that wants to enroll in the voluntary self-exclusion program. And I don't know if there's some way that we can, if there's language that can be a transition language as we work with. I want to work with DPH in order to come up with the one number solution that exists, as well as messaging that would not be confusing to anybody that's glancing at these advertisements.
I think to what I would like to see as a transition sort of compromise here, because we don't have that warm handoff process agreed with DPH yet. I think I would be looking to see that we comply with the statute, and that is to require the Problem Gambling Helpline be included on the platform, and then and that's it, with perhaps, you know, the Game Sense logo. I don't know, Mark, I could take your recommendation there. But then all other advertising, not include the Problem Gambling Helpline, but instead include the Game Sense logo, website, phone number, tagline, you know, just so that we ensure that at least in those mediums, we do get folks who are interested in the VSC. We do get those folks routed to the appropriate place. And in the meantime, the discussions with DPH continue because, you know, Madam Chair, you said it. You thought this was happening already. It's not happening already, and it's my understanding that it's not due to any technical issue. It's just that DPH is unwilling to do it. Not that they're unable to, they're just unwilling to do it. And that's my understanding. And so if that's not correct, then please someone correct me. But the point is, I think we do need to make sure that we have adequate resources available on the BSC side for patrons seeking them.
Yeah, I think, if I may, Madam Chair, my concern though, based on what, and I'm being educated by Mark and everyone on that side, is that if someone's in crisis and the phone number isn't out there, the BSC response wouldn't be the correct response for someone that really needs immediate help. So there's, this is how Mark's explained it to me, is that the sort of the helpline is really people in crisis, mental health, real serious, potentially suicidal positioning. They're able to help there. So I guess the concern is if you don't have that 50/50 number, someone who's in that position is not going to be helped in that respect. I don't know, Mark, if you have any comments on that. And I get it from, having two quote unquote helpline numbers in the Commonwealth is, as Mark has indicated, is not helpful. So that's where we're getting some confusion.
Madam Chair.
Yes, Commissioner.
Oh, I just saw Commissioner O'Brien has.
I did, but I'm actually more interested in Mark was kind of leaning forward. I didn't know if he had anything to say, to add to Karen's comment.
Could I just pause for a second? I could really use a break. There's a lot of statements being made, and I just use a 10-minute break and use the ladies' room and come back, and we can all pause and think where we're going to go with this, because again, we don't have DPH here. We're looking for a solution. The good news is the solution isn't set in stone. So if everybody could just reflect, breathe.
Actually, it's 12:20. How much longer do we have? Should we be taking a little longer to get something to eat rather than 10 minutes so we can plow through when we come back?
Yeah, and I think I've let people know I do have a hard stop today around 3, the latest 3:15.
So just throw that out there. Do we want to do lunch now and then come in for the afternoon, or?
I think if everybody can pause and think about this, because we've got to get to a solve. Maybe we can also continue on the rest, but I didn't mean to interrupt everybody. I just thought I at least need a break. All right, so what do you want to do? To go to quarter up? Does that make sense? Is that enough time?
12:50 would be perfect.
12:50. Okay.
Okay, great.
Thanks so much. Jordan. I only see the top of your head.
Well, I didn't see you at all until you just put your
Oh, when you
camera
were,
on.
no, when you were in the middle of the meeting, when you were, I almost said, are you taking notes? I couldn't tell.
I take notes and I read at the same time because
So
if it's hard for me to look up at my screens.
I got it. But I was just like, just now you were looking down, I go, oh. You got everybody? Christina Black, and let's see. I gotta scroll. Oh yeah, there she is. Mina's back. Okay, I think Karen is, I'll wait for Karen. Thanks everybody for that break.
My dog thanks you as well, Madam Chair.
I'm going to turn to you first, Commissioner Hill, because I interrupted, and I think Mark and Commissioner O'Brien were lined up. I'm glad the dogs are happy. Alrighty, I think we can get started. I think Karen will be joining and Mark will be joining. This is a reconvening of the Massachusetts Gaming Commission, where we started off this morning at 10 o'clock with public meeting number 445. We're holding it virtually, so I will do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon, I'm here.
Good afternoon, Commissioner Hill.
Good afternoon, I'm here.
Good afternoon, Commissioner Skinner.
Good afternoon.
And good afternoon, Commissioner Maynard.
Good afternoon, I'm here.
Okay, and Director Wells and Director Vanderlyn are back. We've got Mina. Mina on page 15 of our public packet. And I can't tell what exact provision it is, but it's the highlighted one on page 6 of the reg. And last I left, I think Commissioner Hill had a point that he wanted to make, and then I believe either Director Vanderlyn or Commissioner O'Brien were up next. So I'll let them sort that out. Commissioner Hill.
So, Madam Chair, thank you. For the newer commissioners, I just wanted to enlighten you on something that happens in other state agencies. So in my former life, I would get a call from a constituent who had an issue either with housing, domestic violence, food insecurities, and we would have to call 5 or 6 different agencies in order to be able to get them the help that they needed. So what ended up happening over the last few years of my career at the State House is that we created a hotline called Mass 211, where a constituent or a citizen of the Commonwealth could call that number and they could get help in regards to childcare, runaway assistance, transportation, food insecurities, housing and shelter. And it has worked very, very well here in the Commonwealth, where we have a one-stop shop for people who are in need. And it's something I was proud of to support during my time at Beacon Hill. Now we come to today, where we're having a discussion where we have citizens or constituents. I still call them constituents, Madam Chair, and I will till the day I'm no longer on this commission. I'm sorry about that. Consumers who may be in need of help when it comes to responsible or problem gaming. And we're talking about a regulation that I had hoped, and I do hope, moving forward, that we'll be able to call one number. And for today's purposes, that number is 1-800 and the 5050 number, where they're going to get an operator 24/7, and they're going to be talked to about community-based resources. And in the future, I hope, through working together, as I know we all want to do and have done pretty good, in my opinion, with fantasy sports, casino gambling. We've all come together, all agencies, whether it's the Gaming Commission, whether it's the Department of Public Health, or our friends over on the Council and Game Sense. The three prongs that I talked about very early on in this discussion. For today's purposes, I think, Madam Chair, you asked us early to give your opinion about the language that was put forth by Mina. And Mina, God bless you for listening to 5 different opinions and then other outside sources and coming up with language that I think gets us to where we want to go today. But then knowing, Mark, we have further discussions that need to take place with DPH, the council, and others involved. And I'm very thankful. I asked the question early on, Madam Chair, about what's an and what is an or. And everybody has been very articulate as to what an and would do for us and what an or would do for us. And I am now of the feeling that obviously it should be or in the language. So my hope is the 1-800-5050 number gets a person to be able to get the help they need today, with discussions with what I love is the warm handoff. I love that phrase. And I'm going to use it again and again whenever possible, that they get a warm handoff and they understand not only community-based resources, but the voluntary self-exclusion program and other things that they may need to get the help that that we all hope they'll get. So I wanted to just bring the attention of the Mass 211 program to my newer commissioners who may not have been aware of that program and how successful it has been for the citizens of the Commonwealth of Massachusetts. I think we're trying to create a similar number for those who need responsible gaming or problem gaming help. So with all that said, Madam Chair, the language that Mina has forwarded to us, I'm okay adopting today, or when we should take a final vote on this regulation. And thank you for allowing me the few minutes to share my views with you on this.
We have something in our email box. Is that what it is? Or the language he's forwarded to us for the responsible gaming? Mina?
Madam Chair, unless Commissioner Hill, I think he means the language in your packet.
Yes, the proposal on page 15.
Oh, my apologies.
Thank you for the clarification.
Because I'm not sure if Mark has seen it.
It's the actual language of 256 that Mina proposed.
Oh, the language he's proposing, but
right.
not the actual messaging.
Right.
Okay.
Correct.
Did Mina come up with some messaging language? Okay.
Oh, no, that is not my job. No.
Okay.
If tasked, I'll do it, but that's, there's enough good people working on that, it sounds like.
I think the messaging language that we're talking about, Madam Chair, is going to be forthcoming. I'm not sure it's something that we have here today, but in sense of putting something forward in our regulations, the proposal that is on page 15 is something I could be very supportive of today.
Okay. So
to be clear.
Okay. So just a point of clarification. I'm going to turn to Director Wells because so we're looking at the reg language, which we need to either give a green light to Mina on. But I think Director Wells is looking to give the operators actual clarity about what responsible gaming messaging is. And responsible gaming messaging maybe need to be tweaked as a defined term. But so Commissioner Hill, unless we say we can't do it, Director Wells, that language isn't going to be here. She is, I think, Karen, I thought you were looking to get some more guidance. So.
Yeah, so I think, and Mark and I were just chatting at the break. I think that the recommendation for billboards is the DPH number and then the GameSense logo. Is that acceptable to the commissioners?
With the required font that's in our reg. That works?
Any objection to that? And I don't think, okay. And then, so then.
I'm sorry. Billboards, the GameSense contact information in the logo?
The logo.
Just the DPH helpline number for people in crisis and the GameSense logo for billboards. That's simple. And then the question was, could we have the proposal of the DPH phone number and their website with the language, if you're, what was the language, Mark, that you have in the current guidance?
For the Massachusetts Problem Gambling Helpline?
Yeah.
If you or a loved one is experiencing problems with gambling, call 1-800-327-5050 or gamblinghelplinema.org.
Okay. And then to address DPH's concern that there's some conflation of the two programs, you could put the language for the, if you're under 20, only for over 21. What's the over 21 language, Mark? Do you have that?
Yeah. I think it just must be 21 years or older to participate or something like that. But it's pretty standard across all operations.
Okay. And then it would be play it smart from the start, the GameSense logo and the GameSense website.
Correct.
That's on everything except billboards.
That's the question.
Karen, can I make a point of clarification about billboards, please?
Yeah.
Or Madam Chair, sorry.
Sure, certainly.
I think that it's important I think that if we just have the GameSense logo and just the problem gambling helpline number, we may run into the same issue of conflating the two. So I think I support the idea. There's a lot going on a billboard to just have the GameSense logo just sort of to build brand familiarity, but we need more of a tagline for billboards regarding the help.
So Commissioner Hill, what's out there right now? Or Mark, do you remember?
I have again, one of our operators over the weekend had done some advertising on TV, and what they had put down is Hope is Here, gamblinghelplinemass.org, but MA, I should say, not mass.org, or call the 800-327-5050 for 24/7 support, period. And then the GameSense.
I think they might use Hope is Here, call in the phone number on the billboards, and then.
Yeah, I think that's their, play smart from the start. That's their counterpart to that.
I feel like I've
So
read
they like that.
but we've given them right now. I don't know the status of the reg. And
So can I, hold on one momento. Must be our UPS man. So just to throw a fly in the ointment, we had a discussion earlier, and I apologize. Hold on one momento.
problem. We can hear you. We can hear you.
He usually doesn't bark. So if we were to put the language in today that says gamblinghelplinemass.org or call the 1-800 number for 24/7 support, period, for now, and this is the fly in the ointment, for now, and then have our discussions with DPH and the council moving forward. I believe I was told earlier that we could come back and with new protocols put into place once Mark and DPH and everybody has had their conversations to put forth. But for today's purposes, to tell our operators what we need, maybe we should make it simple for now until we have that full-fledged discussion on what we want to see move forward, which is not going to happen today because we need all present for that discussion to take place. Just a thought, not how I feel, but a thought.
Commissioner Skinner?
Oh, I just wanted clarification from Karen. So on everything except billboards, you're proposing, or Mark is proposing, or you both are proposing DPH phone number, the website in their tagline, as well as the Game Sense material, play it smart from the start, that tagline, and the the logo and phone number and website?
Yeah,
Just
so
the
that,
website, no phone number.
no phone number.
Okay,
DPH's phone number.
So three things from DPH would be and this is sort of the menu. So you can pare it down. As Commissioner Hill said, you have complete discretion on what you want to do. But this would be sort of the ask from, of the 6 pieces: the DPH phone number, the DPH website, and the DPH tagline. Also, the Game Sense tagline, the Game Sense website, and the Game Sense logo.
Could we have the language for the tagline, please?
Mark, I'll defer to you on that.
Okay. So for the Department of Public Health Problem Gambling Helpline, if you or a loved one is experiencing problems with gambling, call 1-800-327-5050 or gamblinghelplinema.org. For the responsible gaming messaging, it would be GameSense logo, play it smart from the start, GameSenseMA.com. In order to minimize confusion between the two, there would be the 21 plus language that would separate the two.
And that language would be?
I don't have, Madam Chair, I don't have that exact language, but it's something like must be 21 years or older to play.
Does there need to be some real estate between DPH and the RG language, Game Sense language? And I ask that because I think I saw in one example where the sentences just run together. So I'm not sure if, the 21 and older language will just look like more language, or if it's just real estate. And I say real estate because I also wanted to ask both Karen and Mark about the implications of our font size for this, if they've heard any feedback on that.
Well, I think, Madam Chair, isn't that what prompted some of this discussion, as well as the operators are saying there's so much here that it restricts the ability to advertise? I thought that's what prompted the issue on the font size.
On the what?
On the font size, but I mean.
That was on billboards initially, was, to make sure it could be seen, because I think we went so big that it took up the whole.
Okay. And I got information from Crystal. Some of the operators, they just put 21 plus as their information regarding the age restriction.
Yeah, so they're looking for shortcuts, right? Commissioner's thoughts. Can I further, what was your saying, Commissioner Hill? Putting what in the, further complicating things, putting what in the what?
Fly in the ointment.
Say again.
I think you said the fly in the ointment.
Yeah, that. Just a reminder too, that we have the statutory requirement about the platform, but we don't have an associated reg, I don't think, on that.
We do.
But
We do.
We do. So
yeah, it's all good.
So I know that somebody said maybe just the platform would just be the 1-800 number and the website as required by statute, but we could add RG on the platform too if we want. But I think also on all of the platforms, there's an RG button, and I'm hoping that our GameSense program is in there. Mark is going to look into that further. But anyway, just another fly in the ointment.
Madam Chair, I would just add, there could be unintended consequences with all this verbiage that we're trying to put on. And we really should have a discussion with the operators as well as some of the folks who would be advertising. And I would hope that those discussions would take place with Mark and again, DPH and the council so that we can really understand what can be put on an ad that would be helpful to people. If we start putting all this information on, I can guarantee you the font's going to get smaller and we're not going to see the messaging that we hope to put out there. Food for thought.
So that's a good point. Will the font get smaller or will the font stay static because of our reg? And then it becomes an issue of real estate for the advertisers.
Which was the issue that they brought up to begin with.
So yeah. Commissioner Skinner?
Madam Chair, I feel the same way. We started this a couple weeks ago. The language was "and," so the problem gambling helpline and the responsible gaming messaging. And so that is what drew a lot of comment from the operators. And they cited, their inability, I guess, to accommodate, both of those things and still have a successful advertisement. So I do agree with Commissioner Hill that it would be beneficial to hear from the operators about this proposal. But I also want to thank Commissioner Hill for the reminder of the 311, Mass 311, and sort of the communicating the origins of it. I do remember Mass 311 and 211, excuse me. I'm confusing the city of Boston's 311 line. But, and that's how it should be, right? The Commonwealth Collective should be working together to ensure its residents and citizens have what they need in terms of available resources. So, that's my intent, is that the two agencies can work together. But as you pointed out, Commissioner Hill, we don't have that today. So I think, the next best thing right now is to solicit comment from the operators, I guess, again, to find out what that will do, because I do think that's a lot of information. Both the DPH, the 3 items on the DPH side, and then the 3 items on the Mass Gaming Commission side. It's a lot of information, and I'm okay with that. I just I wouldn't want to produce any unintended consequences, as Commissioner Hill pointed out.
Madam Chair, to be clear, I think you asked our opinion. And I want to be very clear in what my opinion is for today's purposes. And for today's purposes, to Executive Director Wells, is we need the 1-800-5050 number for sure. We need the website for sure. A little tagline for sure. That would be the bare minimum of what we should be asking our operators to have in place on their advertising. Then moving forward, they should know and acknowledge that this is subject to change once we have a discussion with and I keep saying 2 or 3 entities of what we would like to see as a commission, because that's going to come back to us for an approval, I would assume, since we will have the ultimate yes or no say on this. But for my opinion today, the 1-800-5050, the website, and there was one other thing that
The tagline, I think.
Yes, the tagline, whatever that tagline that DPH uses, at the bare minimum, but letting them know very clearly that that's going to change very quickly once we have these discussions. That's my opinion, Madam Chair.
Commissioner Meaner?
I think that,
Commissioner Meaner?
thank you, Madam Chair. I think, I never want to lose the forest for the trees, right? Like, at the end of the day, this is about people trying to get help, and we got to meet people where they are, and people are at different stages, right? People need different levels of help, and I appreciate Director Van der Linden for calling me last weekend and having that conversation that, people are at different places, right? And, taglines and branding and all this stuff is very interesting to us because we live it and breathe it every day. For the patron that just needs help right now, right? They just need a clear, easy way to get the help. And I think that like my colleagues, the perfect idea is one number that trees off into various places where people can get the help. But while we're negotiating what that looks like or having conversations with DPH, who does a great job, a fantastic job of doing what they do, and we appreciate them and their willingness to partner here. I think, kind of leave it as is, right? Like the guidance that Mark has given as is working as good as it can today. I think we leave the or in that gives the commission the flexibility it needs to do the changes Commissioner Hill's talking about over time. And hopefully the change won't be too onerous on the operators, because hopefully the change is just adding information to a number to a tree. But I think where I am today is obviously have the number on there for DPH, and then as much information as we can reasonably put on an advertisement to help people get what they need. And at the end of the day, that should be the aim. Let's help people get the help they need.
Commissioner O'Brien, you want to chime in?
Yeah, I mean, I think we're all on the same page, and I'll put a different fly in the ointment for later, which is I think as we move forward on this, I'd love to know, particularly the younger group that ages into this activity and the mobile activity, what's the best way to reach them? Is it really a mobile access or a phone number? Because what I'd really like to prioritize is also just the most effective way of getting people help, which I think might be different depending on the demographic you're looking at.
I'm going to turn to Mina for a clarifying question. Our reg as written, I think I've already mentioned that commission can include for the second clause everything that's in the first clause, should we so choose. What do we need to do to give content to that defined term today?
Today, nothing. This can all happen. The idea of this is that it would continue to be set by commission policy with the ability to change over time and evolve over time as you learn more about the industry and the market.
So what is our policy right now?
So as captured in the reg, it would be that it's not necessarily just what's captured in the reg. It's a discussion that you just had, which if I'll defer to others if they heard this differently, but as I heard it was simple one phone number plus game sense, I believe, and as little other information, but as much other information as you could put on without overwhelming a particular ad. Karen or Mark, I don't know if I got that right, but the reg is intended to leave flexibility as you continue to work with DPH if you want to further refine that in the future.
So if somebody wanted to make a motion on it at some point, it would be pursuant to 256.06, subsection 2, the second clause, and solely the second clause. The Gaming Commission directs Director Van der Linden to, there was something like that.
Correct, and it's not necessarily just solely a second clause, but because it's how you're interplaying the two together. But yes.
Well, that's why these, if we're not clear on that, we want to control the messaging, and I'm hearing that from different, but nobody's being terribly precise because we're sort of being appropriately flexible. the way it's also framed, DPH could be confused because we're thinking of shortening the language that they've actually given in to us. In the first clause, the language is longer. So that's why, that's why I actually am looking for a little bit more firm direction so that we're clear, and then it can be, it can evolve with discussions with Director Wells and Director Vanderlinden and his team and DPH. But right now, DPH has provided language that's, I think, wordier than what Commissioner Hill just said. So Karen, I think probably I'm trying to help you here to give you just a bit more to prescribe so that Crystal can answer when they ask, what do we put in here? And so I'm looking for some certainty about what we're going to advise.
Right. I
mean, I'm not sure we're all in agreement.
That's what I'm not clear on. So my understanding is, it seems as if everyone is in agreement for the DPH phone number. Is that correct? Anyone? Okay. And the DPH website. Okay. And that the language for that would be as brief as possible. So it would be shorter than what DPH already provided to Mark. But the hope is here, that the commission wants that to be as short as possible. Is that correct?
I see nodding heads. We need to just give some verbal direction here. First question, hope is here. I think we've seen. Mark, has that ever been provided by DPH to you?
Yeah, I believe it has, Madam Chair. Okay. Can I make a suggestion? I mean, thinking about sort of keeping each as brief as possible, if we included the DPH focus here, problem gambling line logo and phone number website for GameSense, it's marked from the start, GameSense logo, GameSense website. I think that it would definitely save on some space from what I mentioned just a bit ago.
Could you say it again, please, Mark?
So for DPH,
read it out like what it would be.
DPH problem gambling helpline logo. Hope is here. Phone number, website. For GameSense, GameSense logo, play it smart from the start, GameSenseMA.com.
Did you include DPH's website?
Yes.
Did you say or and, Mark? I thought I heard you say or.
And.
Okay.
Sorry, Commissioner Skinner.
No, the clarification is good because I've been looking at you and I don't think that you had recommended only using the DPH material on the advertising. So I'm glad you clarified that for me, because when we're talking about is there agreement in a direction, I didn't think there was. So you're not okay with having DPH material exclusively?
Not DPH material exclusively. I believe that we should maintain the GameSense information.
Right, so then we stick with and.
That's what I'm hearing.
Because otherwise, yeah, we don't have any control over which one goes in there.
I'm sorry, Commissioner Brown, I might have missed your point.
He's talking about the reg?
I'm talking about the reg, yeah, that if we have or, we don't know which one of those would necessarily appear. So if the request is to have both, it would have to be in.
Madam Chair, my understanding is that on the second clause after the or, that allows the commission just to have complete discretion, which could include the phone number and website and everything from DPH as well.
So say the or, and then the approved message that we're going to authorize today is essentially an and.
Correct. That's exactly right.
Except that we've taken out maybe DPH to be able to use all of its language. And I think exercising discretion around the real estate and the implication
Right.
of advertising, yeah.
Yeah, and also just the practicalities. I think one of the things I didn't comment on is there is no direct relationship, right? So we have the direct relationship. So in terms of us controlling that message in this context makes sense to me.
Okay,
The other wrinkle though is that even though we're saying or, to the operators, it's an and. So we're back where we originally started, where, you know.
No, because we can give
whether-
them, we'll give them the clarity on what the message is.
But that clarity is going to be DPH problem gambling
Yes.
and.
Yes.
So, right, effectively, it's the end, which led
Right.
us this
Right.
discussion to begin with. So I'm
Right.
just, I don't want to go be circular, but that's the reality of it.
Yeah, that's where I said it's effectively, we're keeping or in the reg. Practically speaking, we are telling them it's and, but we are using the discretion to make that decision.
Yeah.
If that's the way we vote.
so I think that you're both raising the confusion that was raised by Mark earlier. And Mina, I'm going to turn to you. We use the term responsible gaming messaging. Does it need to change? Because when I read it, I didn't think of Mark's, reading that it wouldn't necessarily include problem gambling services, treatment services. But I'm really comfortable with us exercising our discretion to that or clause to get it right, to strike that right balance with making sure there's a 1-800 number for problem gambling, as well as the responsible gaming. And Mark, I'm going to give you, if you could give me 2 minutes to recite what you gave us last week, a reminder. What's the difference between problem gambling and tools and responsible gambling tools? Because
Right. So it's on a continuum, and the resources that are provided through the Massachusetts Problem Gambling Helpline are for more intervention-oriented help. So they do a very good job of identifying up-to-date resources that are in the community and making a referral to those resources. Now, if you think more down that continuum towards prevention and some intervention, you have GameSense, and GameSense can connect you with harm minimization tools, including cooling off, play management tools, voluntary self-exclusion. That is the sweet spot of GameSense. Ideally, you should, we want it no matter what you do, no matter where you go, whether it's GameSense, the Problem Gambling Helpline, you can get to the information that you need.
So Commissioner Hill, it's that continuum that I'd like to have reflected, right out, like starting today, as long as we got the real estate, the language right.
Correct. Yes.
Okay, so we got it down to the language, Karen, that you want to, in the order that would actually tell the operators. And I think Crystal would be getting a lot of these calls, right? So she's looking for guidance on.
So is the consensus basically all 6 pieces, but we'll abbreviate the language as much as possible? Is that the consensus? Or non-billboard advertising?
Yeah. I think there's a consensus, absolutely. I guess I would love, I'm thinking it's, my notes say, hope is here, colon, 1-800, or problem gambling line, I don't know which one, colon, 1-800, and then their website and their logo. And then 21 plus, our play it smart from the start, GameSense logo, and the GameSense website. Mark, edit.
Yes.
So what would we start with for DPH?
I think that it should probably be the same order, And for games, I recommend starting with a logo. So I guess I would start with a logo for DPH.
Okay, so make it parallel, but the tagline for DPH, that was the only part that I wasn't clear clarity.
Oh, Hope is here. So
I see it.
logo, tagline, phone number, website, or just website in the case of games.
Commissioners, how do you like that? And then back to Commissioner Skinner's really good point. I think it started with Commissioner Skinner, was we need to hear from, and Commissioner Hill, hear from the operators, but we've got something that we know is a little bit more concise and perhaps workable for them to get going today. Karen, does that help you? And we can get, and then they'll give feedback on it as soon as they start to implement it. And we'll get feedback from DPH. Commissioners, are we all in agreement so far with that? Okay, I see Commissioner, okay. All right. Nina,
So
I think can we move on then?
I'm okay with that. And just on your, I think the one last point, and I'd hate to slow us down on this, but is the defined term responsible gaming messaging. We did not get any comments from the operators about confusion there. Their comments were strictly on the amount. If we were to change it to anything, I might suggest something like required messaging. The reason for it is, like the operators, we were worried about real estate. We were constantly repeating the same phrase otherwise. So I don't know if it matters too much at this phase, but if with this description and the clarity on what you're requiring, if the language is fine, I just as soon move on, but we could also change it to required messaging.
Anybody feeling strongly about that? Commissioner Skinner?
I like it as is. I think the objection came from DPH. Could we just understand what the concern is there a little bit more, Mark?
I think the concern from DPH was that there was confusion about the difference between Game Sense and the problem gambling helpline. I thought it was conflating. There was also that in certain situations, there were two numbers, which I think that's addressed here. So as I understand, Commissioner, that's the crux of the concern.
Mina, I think you were talking about the defined term. And Commissioner Skinner, I'm not sure if DPH raised that issue. I think Mark may have raised that issue today. I don't know if anybody else can help here. Mark, I think you raised that responsible gaming messaging would sound like it was just RG and not problem gambling as well. Is that?
Yes, that's right. As I don't have the regulation pulled up before me, but the concern was that the term responsible gaming actually included problem gambling helpline information as well. So, and they're distinct.
So Mark, the way it reads is the issue about Department of Public Health language or such other responsible gaming information as required by the commission, responsible gaming messaging. And so I think Mark was, as we use we have an expanded view of that second clause, responsible gaming messaging seemed narrow to Mark. I think that's what I'm gathering. So that's why I think Nina was thinking required messaging. This is definitely nuanced.
Yeah, I think 6 in one, half a dozen in the other. I think the intent is clear. So I mean, I'm not committed to either way, but I do like this sound of responsible gaming and what that conveys over the required gaming messaging option.
Okay, so somewhere we just need to memorialize in a policy something, Karen, that says what we end up voting on today for that language. And then we can tweak it. Anytime anybody wants to bring it. Okay, so we move on then?
Sounds good.
Yes,
Thank you.
Thank you all. All right, so there's only a handful of other comments, and then I think we can make sure we've circled back to any loose ends. In the bottom of page 16, this is 256.065. This is not actually new language. This is just there's mandatory unsubscribe language. The Attorney General's office suggested moving it here with all of the advertising to vulnerable persons, as opposed to just in the self-excluded persons section. It always applied to everything, but just a change in location. So no change in language. So I can move on if that's okay. 256.10.1. There's an addition for maintenance of records, especially for social media sites, but in general for the advertising, to not only capture the record of the ad, but the record of targeting parameters that might have been used or limiting factors, to show that there was compliance with, for instance, the social media provisions we talked about earlier, to make sure you're excluding underage folks. So that was a suggestion from the Attorney General's office. They had it suggested sort of a few different ways, but it's consolidated in one place here. And we thought that made sense to add. And that is, I believe, and let me just note one more, 256.092. It's not highlighted, my apologies. This simply repeats and is consistent with the disclosure obligation I mentioned earlier for endorsements to include a disclosure of the relationship. So there's no misleading impression that someone is speaking on their own behalf with no connection to an operator, when in fact they're speaking and being compensated by an operator. So I think that's it for 256. We can circle back to the first issue we discussed if others are ready. I don't know if Todd or Carrie, if you want, or Kara, there's Kara. If Kara, you want to let us know, but I'm all set.
Hi, Kara.
Hello, good afternoon.
Good afternoon.
So we took a look at the applications received for both the revenue share agreements and did kind of a high level survey of some of the other marketing affiliate applications, which would include CPAs. The only data that we really have in terms of the company on the revenue share side is the estimated annual value. And we have a range there of essentially mid 6 figures to low 7 figures in terms of that annual value. We do not necessarily have that on the CPA or flat fee model, because that's not a part of that application. I will say anecdotally, we've heard from a couple of marketing affiliates that indicated that they had been interested in doing marketing in the Commonwealth, but the value of their contracts with operators, would not make it worthwhile in a business sense for them to pay the $5,000 registration fee, which again is that lower fee. So the $15,000, would certainly be more than that. I also just wanted to mention, in terms of that estimated annual value, we also don't necessarily know the number of contracts, because that's not asked in the application. So they could have essentially a number of contracts with different operators. So there's nothing that would bar them necessarily from doing business with only one operator. So there could be one, there could be 5. We don't have data necessarily from the application. The one last item that I wanted to mention is that for the applications where it has been logged, we do not have any vendors that indicated that they were minority owned, woman owned, or veteran owned. That's not to say that there aren't any that haven't been logged yet, but of the ones that we have gone through, which is the majority, there are none that have provided certification and such.
Questions for Kara?
Just a thank you for looking into it.
Happy to do it.
And it's the annual value.
So the estimated annual value of the goods and services provided to the operators that they have agreements with.
In Massachusetts.
Yes.
That's your point, that they could be having multiple elsewhere.
Well, no, sorry, not even necessarily elsewhere, but if, for instance, a particular marketing affiliate is providing services to more than one operator, there is no data necessarily on the number of operators that value is a result of.
Yeah, I understand.
Okay.
Yeah, we'll clarify. Yeah. Okay. Any other questions for Kara? Any clarification on what a small business is in Massachusetts for the purpose of the certification that we must make? Anybody look at that reg? I wondered if the reg has a definition.
I'm sorry, I don't have any clarification on that. We can look into it. But I don't think we have that as we sit here.
So the when we get to voting, it's in there, the reg that's, where is the small business? Okay.
It's on page 82 in this case, Madam Chair.
Yeah. Is there any definition in that reg? Do we know? I can pull up the reg if need be. $205.56.
205-256 is your reg. It's
Oh, that's ours. That's right. That rings a bell. So nobody, we don't have any reference to the Secretary of State's definition. Is it in 30A?
So the small business impact statements are described in chapter 30A. And I don't believe there's a definition of small business, though I could double check that. I'm not sure there's a regulation that discusses that.
Madam Chair, or Todd, I have it if it's.
Oh, you do? Okay.
Yes, it's 38 chapter 38 chapter 5, excuse me, 38 section 5.
Yeah.
Is what sets a requirement to study small businesses. A small business is defined in 30A section 1 as a business entity or agricultural operation, including affiliates, independently owned and operated, with a principal base of business in the Commonwealth. So it is limited in Commonwealth. And 3 would be defined as a quote, small business under applicable federal law. So it follows the SBA's definition.
What would be?
The last part of that is it has to also, so it's sort of a 3-part test. Give me 1 second. Read that again. It's a independently owned and operated place of business in the Commonwealth defined as a small business by the SBA, the US SBA.
By the SBA, so it has to be like, make a determination as the SBA, got it. Okay.
And the Department of State's definition of a small, or their website on it, what is a small business? It's kind of differs based on industry size. So I don't think there's a uniform definition. In other words, what's small in one business may not be considered small in another.
Thank you. All right. Any other questions for comments on this section? My observation here is that if we were to adopt today's recommendation, we are not adopting the New Jersey version because we are eliminating a rev share arrangement that New Jersey allows with additional guardrails. Am I right?
Correct. Correct.
So it is different than what we agreed to last time. We are putting up restrictions on revenue sharing that at least New Jersey allows. And
Madam Chair,
yes,
could we just have clarification as to what that is?
those
What
last,
we're prohibiting that New Jersey allows according to the advisory that we reviewed earlier today.
the 3 bullets that
Sure.
Nina went over.
Yeah.
But New Jersey doesn't allow those, and we wouldn't either, right?
New
That's
Jersey
my
does
understanding.
allow
Oh, New
Allows
Jersey
someone-
does allow, okay.
with a heightened licensure. So our interim measure, Commissioner Skinner, if I'm right, reflects the New Jersey model now. And what we'd be moving to if we adopt today's is taking away what is allowed in New Jersey with heightened licensure.
You are right, Madam Chair.
Is that right? Okay, thank you.
Sorry for the confusion, for my confusion.
No, that's okay. I've gone circular on this many times, Commissioner Skinner, so thank you. And I think I might be in the minority, but I still am thinking of our roundtable and the plea from the folks who are a very small group, 5%, who are saying we won't be able to enter the space if we go with the CPA is the only option. And that was what is the name of it again? The Gaming Associates or Gambling is from Mr. Garnett.
Gaming Society, I believe.
Thank you. Yeah. So I'm struggling with that, but it's on me. So we have a reg in front of us. One point of clarification, Carrie, today, if we vote for this, what happens to the suspension and the April 14th deadline?
Yep, so the waiver would stay in effect until April 14th, and then this version would go into effect on April 14th and take over for the waiver. So the new language would go into effect on the 14th.
Well, I really appreciate the Attorney General's offices weighing in, and I know that there's been a kind of a compromised language here. I guess I would just point out that I also know that they really very much value the impact on small businesses, and particularly those that are MBEs, WBEs, and VBEs. I guess if this stays into effect through April 14th, that will give us some data that might help inform if there is any impact on these businesses as anticipated for Massachusetts. So, that that might be helpful to, for all of us and for the Attorney General's office. But again, I'm not sure if they saw Mr. Garnett's letter, but it's or heard the roundtable discussion, but it did stick with me. I think Commissioner Skinner, I don't want to speak for you, but you and I have, I think, repeated it. You've done it in a different fashion than me. But I just still am sort of stuck there. Maybe you've gotten more comfortable and I'm sort of still stuck.
So am I, but I think the compromise language is a good way to, I think it strikes a good balance between the AG's concerns and the operator's concerns. And I think it's the right direction in my mind.
Okay, great. Commissioner O'Brien?
I was just going to offer a motion if we're ready for it. I assume, Mina, starting with advertising and then we circle back to 202?
Yes, Commissioner O'Brien.
Yeah. Okay. I move that the commission approve the amended small business impact statement and the draft of 205 CMR 256 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Okay, any further questions or edits? Okay. Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner May?
Aye.
Yes, 5-0.
Do we ready to move on 202 or do we need to talk
I
about
think
it?
let's bring it to
Yes, I don't think there'll be. Yeah, I'm just bringing the page up. It's page 3 of your packet.
Yeah, that's first. That's right.
So it's been a couple of days since we reviewed it. I'm happy to just go through it very, very quickly. I don't think we will not recommend changes at this time based on today. If 202 is one we do plan to revisit on, occasionally as we go through other regs. Any regs related to category 2 might trigger some more revisions, as well as the data privacy and further regs on that. So 202, the changes, just as a reminder, is clarifying that the application of the reg is for the entirety of 205 CMR, but that the words in the 100 series definition section will apply unless the context requires otherwise. Responsible gaming messaging, I think we all know what that means now, is on page 5. That's added in here as a defined term, and that's it.
Any questions for Mina? Do I have a motion?
Madam Chair, I move that the commission approve the amended small business impact statement and the draft of 205 CMR 202 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Any questions or edits? Okay, Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner May?
Aye.
I vote yes, 5-0. Anything else, Mina? Anything else, Executive Director Wells? Commissioners, anything else? Legal, we good? Okay, thanks everyone. Excellent work. We got through this. What does this mean for the future, Karen? Wednesday, I don't think we need to convene after.
Yeah, so we had already Grace has already posted the meeting for Wednesday, the 29th, so we could take that down off the website and update the Secretary of State's office, so we would cancel the meeting for Wednesday, but we do have a commission meeting for Thursday with numerous items on the agenda.
And we have agenda setting at 10.
Yes,
On
and
Monday.
that's
On
been
Monday.
followed as well, so she took care of it.
But keep that, but I see Grace is tuning in. Grace will work to cancel that Wednesday with Dave and Trudy, and we've gained some time. Congratulations on getting through this advertising, commissioners. It's been a very thoughtful process that started way back. So Mina, thank you for the guidance. Appreciate it.
Thank you, Madam Chair.
Okay, do I have a motion to adjourn?
Move to adjourn.
Second.
Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. 5-0. Thanks, everyone.
Thank you.
Thanks.